some kind of a reconveyance. And at that point, is my property free and clear? In the public, right? Okay, so our process is going to simulate this. Anything outside of this box in form in the public, you're going to be creating probably more problems for yourself. So, nothing about UCC1s, right? It's part of the typical public process filing a UCC1? No. Does it have anything? Is anything else recorded in the county records on the property besides the reconveyance? No. Now, there's a couple other elements we can add to this if you are already in default. Okay? If you are in default, what else would be a part of this public form? Well, no. I didn't say you lost possession. I just said there was a default. The notice of default was filed. Why? Is there litigation? Judicial states are saying there's a lis pendens because it's in default?
It literally makes my body feel younger again.
For whose benefit? Who's the secured party on that lien? Okay, so in a mortgage state, a lis pendens lien is filed with the court. Okay?
Lis pendens meaning pending suit.
Pending litigation. That the title is now in question and nothing is to happen on this title until the litigation has been resolved. Okay? Now, again, we want to simulate what happens in the public. So let's say notice of default went out, but now I wrote a check for the full amount owed. What would be added to this process? Satisfaction of default. What goes into the public record if the default has been satisfied? If there was a lis pendens, would it be released? So there'd be now a release of lien. What cancels the default? What in the public record shows that the default has been cured? Notice of rescission. The default has been rescinded. Okay, so before the release of lien, there would be a notice of rescission.
Who makes that notice?
Typically in a public transaction, it's filed by the trustee. Who orders the trustee to file things in a deed of trust? No. Beneficiary. Beneficiary tells the trustee, notice of rescission. Beneficiary tells the trustee to release the lien or to reconvey the deed. Okay, so that's what it in form looks like. So our process from a public point of view will look exactly like this. Nothing out of the ordinary. So get that in your head, that before you even start your process, what would this look like? For instance, let's say there was a judgment. Let's say now I'm stepping outside of this scenario, and I'm saying there's a civil suit where a judgment was rendered, and let's say it was a complaint for money. And so now you've got a judgment against you for an amount of money. What would that typically look like? Okay? Payment was made, right? So we got another payoff. If they had filed that in the county as a lien, under the abstract, like they filed an abstracted judgment into the county records, there would need to be some kind of a release of the lien. Maybe something like a release of judgment will go into the court case itself. Okay? So that model, what's that? Satisfaction of judgment, something along those lines. And again, who would execute a satisfaction of judgment? Does the defendant execute it? The judge? But who initiates it? Or the plaintiff? Right. Okay? So again, we're going to simulate the public process with our private process in the background. None of our private process ever makes it into the public. It stays private. Okay? So the public will always look the same. Even if we're using private processes to achieve our remedy, in the public, it will look as if any other payoff had happened. So paying with a check will look just like paying with your private asset account in the public. Now, we all know that the process is much different. Writing a check typically is a lot easier than executing an administrative process. So, that being said, let's look at the private process that will lead us to simulate this public model. Okay. First thing we want to do, I'm trying to fit all of this up here. Okay. Move this chair. All right. Everyone can see these, right? You can see this? Okay. So how a creditor brings remedy. What's step one? Settle the account. Just like here, right? Before any of the public record is going to show the satisfaction of this account, or the satisfaction of this situation, first the account needs to be settled, right? So we're going to settle the account. Now we're not going to write a check. Well, you could write a check. But if you're doing a private administrative process as a creditor using asset, you're not going to be writing a check off a public account. But you need to have the knowledge, the fortitude, and the competency to execute a private process and use your asset account to set it off. So, here you'll see a list of the documents for step one. Can everybody read that? I was trying to figure out a way to make the words bigger, but I couldn't figure it out. So we've got, if you can't see, document number one there is a notice to set off. All right, so we have a notice to set off. Actually, so I see I actually separated the documents. There would also, there would also be a negotiable instrument that goes into step one here. Where are my instruments? This process, instruments, okay. So one of these, and for these purposes, I'm going to choose money order. Okay, so this bottom half, just so you know, this money order that's going to be in your samples, you would detach it right here at this line, and all you would submit is this bottom portion. And you would not only sign it down here under authorized representative, but you would endorse it on the back, just like an endorsement of a check, okay? This memo account here would be your Social Security number, okay? Alrighty, so...
Have you used this for mortgages worked?
I've never used this on mortgages. I use the bonded promissory note, but I don't have that. I don't have the sample bonded promissory note in that folder yet. So I typically...
I've had luck with paying off mortgage or somebody else.
Hold on. We'll get there. I'm going to show you how you are not dependent on anybody doing anything in this entire process. Okay? So you're not waiting for someone to do something for you. If you've tendered the instrument, boom, sufficient. Payment's been made. And you're going to get everyone's agreement that it satisfied the debt. That's all you need. Okay? Now, you could choose your instrument. You could use the bottom half of your payment coupon on your actual mortgage statement if you chose, and do an accepted for value on it.
I did all that. I haven't.
And you're waiting for somebody to do something,
I haven't
aren't
done
you?
anything back.
You're not waiting for someone to do anything back. That's not how a creditor operates. Okay? Alrighty.
I feel I see zero on my account.
So now you're waiting for someone else to issue the statement of account. Let me get through step one. Okay. So on step one, we had the documents, and I added an instrument there. Okay. Like I said, it could be a bonded promissory note. It could be the mortgage statement itself, with your acceptance statement on the front and back, and make the payment coupon into a money order. Okay? You could make your own money order like the one we're using right here, or you could use a bonded promissory note. You can use a certified payment bond, whatever you choose.
What is a bonded promissory note?
Bonded promissory note necessitates that you already have something on deposit with Treasury, the way that we've structured ours, because it's basically putting up that account or those bonds as the bonds to set off the debt, and the note is the instrument to make that happen. Okay? So if you don't have those in place, don't worry about it. Use something else. Okay? Those of you who have indemnity bonds and set off bonds on deposit with Treasury, then you could use the bonded promissory note. What's that? Well, no, this is my own. These are my own folders. Yeah, no, it's not going to be in here. But I do need to change that to view. Okay. All right, so back to step one. Okay, so we have, right here in step one, we have a notice to set off. Now, this particular, I think yesterday we mentioned how we're going to tender our set-offs through the IRS, correct? All right, so that's how this particular process is structured. So we're going to issue a notice to set off. We're going to issue our instrument. Now, if you have a statement, like let's say you got a payoff statement, that would also be included in here. All that's in this list are original documents that we're issuing. However, there should be some evidence of the debt also sent in this process. And that evidence of the debt should have a banker's acceptance front and back. If it's a 4-page evidence of debt, let's say you get a 4-page statement, each page, back and front of each page, would have your acceptance statement on it. Accepted for value, return for value, or accepted for value, exempt from levy, deposit to United States Treasury and charge the same to, blah, blah, blah. Whatever acceptance, banker's acceptance statement you use would be front and back of each side of each page of the statement, of the evidence of debt.
Back to?
Front and back. Okay? So we have the notice to set off. We have course, have our instrument, which is the money order. We have our evidence of debt. We have a 1040V, and I also have a document here which shows what special endorsement goes on the back of that 1040V. And a process that me and my friend Doug have created, we've incorporated this into our process, but what I would suggest is that unless you have a Treasury Direct account like we do, that you eliminate these points from your process. See, what we do is in our notice to set off, we basically instruct the IRS that if there are any overages or any amount of money to be returned, that it's to go directly to the Treasury Direct account. Okay. Did you get a check back on a for V?
On the mortgage thing,
Yeah. So, well, this is on our, for what we're doing, it's for, we've actually had people who've done A for Vs through IRS and gotten checks back. And so we're instructing the IRS that we don't want a check because we're creditors, we don't create debt. And what would happen if I took that check, endorsed it, and deposited it into a bank account? I've converted my private asset into public debt.
Yeah, I did. I did that. They reversed it.
They did reverse it. Okay, see, you don't want it to go, you don't want to, we're not even authorized to create public debt out of our private asset. And we don't want to as creditors. That's what the banks do. They are authorized by Congress to convert your private asset into public debt. That's what happens on your promissory note. Your private assets are converted into public debt. So what we're doing is we're instructing them as a part of our notice of set off to don't send us a check. Send that to our Treasury Direct account. Why would I have it sent to a Treasury Direct account? And what is a Treasury? What's significant about Treasury? What do you do with a Treasury Direct account? You buy government securities. What does that make you if you buy government securities? A creditor. You're actually turning your straw man into a creditor of the United States. Because what you would do after that money ends up in that account is buy bonds and notes of the United States. When you buy bonds and notes of the United States, you're the creditor. So that's why that IRS Form 8888 is there. That's where we put our account information for our Treasury Direct account. So like I said, you don't need to use this part of the process. Because of where we're at in our processes, we have this in the process. But most people don't have a Treasury Direct account, and I wouldn't suggest you do this unless you have one. Okay, and then we have our certificate of service. So now we're going to look at these actual documents for step one. Oh, shit. Hey, Garrett, can you unplug my antenna, the little receiver for this thing, and plug it back in? Stop working. It's on the back. It's on the back. Just unplug it and plug it back in. Did you unplug it? Do it again. No, I got it. Got it. Okay, so notice to set off. So, how do I distinguish my private contracts? Well, an easy way is to put this little notice at the top of all my private contracts. This is a private communication between the parties. Notice to agent is notice to principal, notice to principal is notice to agent. Notice to set off accounts. And I'm also very selective in prepositions that I use. This is notice to set off accounts. And in fact, that's not a very quantum way of saying it, so that preposition is actually an adverb, but it's showing that this is a notice for performance. I could call it a notice for performance of set off of account. So I'm basically noticing who? Who am I giving notice to? IRS Tech Support. Now, because lately we've been having success at a faster rate going through Ogden, typically we direct this through the mail stop 4440 at Ogden. Okay, this particular one has the address for Technical Support Division at Washington. You can use either one. You could contact IRS and say, where do I send set-offs to? Where's the best location to do set-offs? Because we used to use a location in San Francisco, but they don't do them there anymore. So a year from now, 6 months from now, 2 years from now, this may be irrelevant information. And a way for you to find out where the relevant place to send it to would be communicate. Open up a line of communication and figure it out. If If I've got a tender for set off, where does it go? Okay. I have a little line here for service, and this is by registered mail with a return receipt. And there you would have the registered mail number. Here, it's giving a brief description. Whoa, whoa, whoa! Slow down. It's giving a brief description of what's included. Okay? This particular document is designed around a franchise tax board debt. So rather than there being, number one, a original notice of state income tax due, this would be an original mortgage statement of account, or whatever the title of your monthly statement is. Issued by name of the bank who issued it, and dated whatever the date of the statement of account is. Duly endorsed as follows. What's duly mean? In accordance with, proper. And then it has there the acceptance statement that is endorsed on the front and back of the mortgage statement. Accepted for value, returned for value, exempt from levy, prepaid common stock, discharge all presentments and related fees, adjust the balance to zero, private prepaid treasury account number, blah, blah, blah. Charge the same to whoever at blah, blah, blah. Okay? Signature and date. And then number 2, original IRS 1040V payment voucher, duly endorsed as follows. So this is also the endorsement that appears on the back of the 1040V. Number 3, original IRS Form 8888, direct deposit of refund to more than one account. And that's where we put our account information, God darn it, for our Treasury Direct. Okay, so these instruments are being tendered by so-and-so, hereinafter principal, for the set-off of, let's say, ABC bank account number, whatever, and are to be used to effect debit and credit accounting transactions for the settlement and closure of said account. If any of the enclosed instruments contain any defects or are incorrect, incomplete, or inaccurate, please return the same to the principal via the notary public at the address shown above within 10 days from the date of receipt. No, it's not. Somebody else typed up this document. Actually, my friend, whose name I erased from the money order, he typed this one up. It's not that it's improper to have it separated, because they both would have the same meaning. And you could find definitions for as a compound noun and as two separate. Okay? It's just as far as language goes, when you compound it together, it's clear that it is a noun and that there's not an adverb-verb relationship between the two words. To set off. When we combine them together, it's a set-off. Right? Alrighty, so so-and-so, account number 123456789, has an open Treasury Direct account, blah, 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 established with the Bureau of Public Debt for the purpose of purchasing and setting off public debt with private equitable assets, as outlined in the Chicago Federal Reserve Bank's publication entitled whatever. The included IRS Form 88 indicates the account number and routing information associated with said Treasury Direct account to ensure that any credits, refunds, or overpayments are directed to this account and not returned to the principal in the form of a check, promissory note, or other liability instrument. The principal hereby grants and conveys to the IRS Technical Support Division or any of its agents the authority to direct any refunds or overpayments as credits ledgered to account whatever. Please exercise ordinary care as the party entitled to enforce these instruments to ensure that all debit or credit transactions ledgered to both the bank account and, in this case, the Treasury Direct account and the straw man name and account number are done so in the best interest of the United States Treasury. Thank you for your consideration. I look forward to a relationship that is mutually beneficial to all parties involved. Until then, it is my pleasure to always be. Okay? So that is our notice to set off accounts. Now, lately, we've been doing this step 1. Now, like I was just making the comment a minute ago, that we're not depending on anyone to execute anything in order for us to complete this transaction. However, as far as proper form goes in getting set off via private asset through the IRS, it is more likely to be properly processed by the IRS if you do not include this form. And we've actually been perfecting a process where we do not use this form in step 1, where all we send in is the money order or instrument, which could be the endorsed payment coupon, the evidence of the debt with the acceptance on both sides, and the 1040-V. That's it. We still present it through a notary, however.
Creditors in Commerce workshop sessions, hereinafter sessions, are the private exchange of ideas and concepts between the providers and the recipients. The content is not meant as legal advice. The use or attempted use of any idea or procedure discussed in these sessions, as applied to the recipient's own personal transactions, cases, or controversies, or applied to other cases, may or may not result in a favorable outcome or the same outcome as discussed in these sessions. Each transition or transaction, case, or controversy may be different as a result of unique actions or unique statements made by the parties therein.
If the number of pages changes, you better change that. I've actually even made that mistake before, where I'm like rushing to get my process out, and because literally I'll change my process 5 seconds before I'm sealing the envelope, and then I forgot to change that part. I'm like, ugh. Had 8 pages and I only included 7. Okay, so I would suggest, especially if you're just beginning, never rush your process. Now, you can always nunk-pro-tunk it, but don't be racing to get your process out. That's when you really start to make mistakes. Ask my brother. When we first started doing this, we were trying to handle 10 or 15 debts at once, and everything was rushed. And we made ridiculous mistakes all over the place. Now, I marinate and I sit on my process. And I read it over and over again. And I still find mistakes. As seasoned as I am at doing this, sometimes I make stupid mistakes. Okay? So, don't ever rush your process. One of the best pieces of advice I can give. Yep.
On the V and on any of the stuff you sign, I think we're signing it as a creditor, so it's not a AR, right?
No.
No AR.
I don't think you'll see AR on anything that I'm doing here.
Right. And then without recourse?
Nope.
Nothing.
Nope. Be careful what you use without recourse for.
Also, remember, if you abbreviate, that's not a good thing. So don't be using AR on anything. If you want to spell out authorized signature, that's okay, or whatever you're going to do, or authorized representative, but don't put AR there because it's not recognizable in law.
Okay, so we called that step 1, but here we are, step 1 is complete, and we haven't even addressed the bank yet. So step 2 is actually our step 1 with the bank. Okay? Now, I'm going to call it step 2 because you guys know that step 1, we were dealing directly with the IRS. Now, we were addressing the IRS in regards to an account with the bank, but step 1 had nothing to do with the bank itself as far as a party to the transaction. Now, the bank is a party to a transaction with the IRS, but we are arm's length from that transaction. Okay? So, step 2, 2 simple little documents. Well, you'll notice I usually put, usually my documents or processes, I put it all into one document. Okay, so this isn't just one document, this 2.2 notice of tender. It has my certificate of service in there. It has a request regarding a statement of account in there. There's different elements to it, but I put it all in one document.
Also has a copy of what you sent to the IRS plus your certificate of service?
Hold on. Well, not in the Word document. Now, we're making a distinction here. These are the documents of the template. The process itself will incorporate documents that we will discuss right now. Now, first, before I move to step 2, I have in here a certificate of non-response. What is that certificate of non-response for?
It's for your records.
Who is it on?
Me on the IRS.
Notice how it's 2.1. It comes before I've even corresponded with the bank. I've put these numbers in these orders for that reason. This is 2.1. 2.2 is the beginning of my action or contract with the bank. So before I go to the bank, what am I certifying? That the IRS didn't send me anything back.
The IRS actually accepted.
That the IRS accepted the tender for set-off. Now, again, in the processes where I have not directed them to send a response through the notary, can I certify their non-response? No. Unless my official address with the IRS is my notary's address. You do understand that? Okay, so the notary cannot certify a non-response unless I sent that notice to set off accounts, which instructs them to send it through the notary. Understand? Okay.
You give them 30 days, the IRS?
No, 10 days. It's just 10 days. Alrighty, so here we go. And actually, I will show you this just to... Oh, I forgot I already had it open, didn't I? Yeah, okay. So I just shrunk it. Okay. Now, it's important to make the distinction that all of these certificates are not the same. That they must be relevant for your process. So you'll notice on this certificate, there's no mention of a notice being sent out. Because I am not giving them notice of a fault or of a default or of anything else. This is merely the notary certifying that on this date, this was presented to these respondents, signed by this person, requesting acceptance, notice of defect, or notice of dishonor. Because a notice of dishonor would be the proper response from the IRS if they could not honor what it was I sent them. I've only ever received one notice of dishonor. It was from the Secretary of State on a credit card payment. The Secretary of State does it right. Better believe it. Even with public instruments, they do it right. By the UCC. Because they're always working in international commerce. Okay. Now we will move on to document 2.2, notice of tender for set-off. So remember I told you prepositions are important. This is a notice of the tender for set-off. The last one was notice to set-off accounts. So what I'm doing is I'm noticing the bank now that a tender was submitted for set-off.
You said notice of the tender, yet the is not in the cap. Is that what did you intend to put the in there?
No, I said notice of tender for set-off. If you were to properly quantify that, it would be for the notice of the tender for the set-off. Okay? Or for the notice of the tender with the set-off.
Brandon.
Going back to the certificate of service, I noticed there were 2 lines on each side of the page. What is the purpose of that, or is there any purpose for that?
There's no purpose for
Okay,
that.
just makes it look nice. Okay, because when you put things in a box,
It's not in a
it's
box.
not there. It's not a box. I didn't know if there was a
You
certificate.
will see boxes later, though. I do
Okay.
use boxes.
All right, thank
Okay.
you.
Okay, so we have labeled the notice with a date, with the registered mail number, same private statement at the top, because this is a private contract that we're initiating with the CFO. We label the creditor as the principal in this document. We label the CFO as the respondent. You see those labels? Right there? Principal, respondent.
And actually, in full, it's principal debtor.
What's that?
If you wanted, you could say in full principal debtor, but I mean, you're saying principal.
Yeah, I'm saying principal, and really, it has no other significance than I could say lender. I could say Cookie Monster. It just means in this document, this party will be referred to as principal. It has no other significance other than that. So I could just say Cookie Monster, and the name, and then whenever I say Cookie Monster down here in the document, it means that up there. That's a definition. You see that? Principal is being defined. Respondent is being defined.
What he's also telling you in law, that's important because like you take the United States Codes annotated, they'll define United States 31 different ways in that document.
Exactly. So this is a definition. I have defined principal and I have defined respondents. This is regarding bank account number and one of the parties to that account, the debtor, right? Dear Mr. or Mrs. So-and-so, whereas on April 6, 2010, instruments of tender for set-off, hereinafter tender, all capital letters. What is that? No, I have defined tender as the instruments of tender for set-off issued on this date. Okay, so whereas on April 6, 2010, instruments of tender for set-off, hereinafter tender, for the set-off of mortgage account number, hereinafter account. I've just defined 2 terms. Account being the mortgage account. Tender being the tender for set-off that was sent to IRS. Were presented for set-off to, down here it has Tech Support Division, Washington, D.C. If you had sent it to Ogden, it would be Internal Revenue Service at Ogden. Whereas on April 20th, 2010, the tender is deemed accepted for the set-off of the account. Notice, now I'm using 2 of the words I defined. Whereas on April 20th, 2010, the tender, all caps, is deemed accepted for the set-off of the account, all caps, pursuant to and evidenced by the records enclosed herewith.
Do you notice a question, Brandon? I notice that you have April 6th date when the tender, and whereas April 20th date is deemed accepted. Maybe you could explain that to me.
In this particular process, the certificate of non-response was executed on April 20th. Now, if we had done a process where there was no notice to set off accounts and therefore no certificate of non-response, this could be 11 days after that. So it would be April 17th. Why?
3 days.
Why 3 days? Why can I deem it as accepted after 3 days? Anyone read reasonable time and seasonableness from the UCC? You better have. All my MIC students know what reasonable time and seasonableness are. In commerce, we have reasonable time and seasonableness on transactions. So I can deem it that because in commerce you have 3 days to dishonor the instrument, and allowing 4 days or 3 days for the mail to get there and 3 days for the mail to return and a Sunday, they've had sufficient time to dishonor the instrument or to return it for defect.
Seasonably meaning simply timely.
Mm-hmm.
UCC uses that word in that context.
Yes.
So
if you're
when,
interested in finding it, you'll find it has its own little subsection. It's less than a paragraph in the UCC under Article 1. Reasonable time and seasonableness. Okay. Therefore, the principle, or therefore, so-and-so. Now, even though I defined principle at the top, I am now restating that definition in the body of the document because those first definitions appear outside of the content or the body of the document. So I'm going to redefine respondent and principal. So therefore, John Henry Doe, hereinafter principal, all capital letters, requests that, and actually, it's a different term. Remember up at the top, the definition was proper case, capital P, lowercase, rest of the word. In this case, I'm stating the name of the principal, hereinafter, principal, all caps. Those are really two different terms, just like Brandon A. Adams, all caps, and Brandon A. Adams, upper and lowercase, are two different entities. These are two different words, two different definitions for each word. The principal at the top, which is upper and lowercase, includes a care of address during notary public. This one is just the name. Request that the balance of the account, which we have defined, be adjusted to $0 to reflect the ledgering of said tender.
why did you capitalize 0?
Because you always capitalize numbers. Yeah, it's a proper name. You guys didn't know that? Yeah. Like if you were to write a longer number, like let's say I'm writing 700,336, it would be capital T in the 3, it would be hyphen 100, but the H would be lowercase. Or wait, what did I say? 3,000 or 3,000, right? So it would be 3, the capital T, HREE dash 1,000, lowercase 1,000, space 300 or 700, the capital S or capital T, whatever I'm using, hyphen 100, and then the word 36, where the T in 36 would be capitalized, hyphen SIX, and that would not be capitalized. You need to learn, I've learned all this through style. Look at English style manuals. Now, you don't have to learn it.
What's a style manual?
Style manual is how to interpret the language, how the customs of interpretation of the language.
Is there not a U.S. style manual and a Chicago style manual and all sorts of style manuals?
Hundreds of style manuals. There's legal style manuals for the interpretation of legal process. Okay? So, basically, whereas on such and such a date, tender for set off for the account was presented for set off to this party, whereas on this date, the tender is deemed accepted to set off the account pursuant to the evidence of the records enclosed. Therefore, principal requests that the balance of the account be adjusted to 0 to reflect the ledgering of the tender. Okay? Enclosed herewith is a request regarding a statement of account. Now, I've actually, in my process, I've removed this California Commercial Code because I don't depend on any code for anything. Mine is purely private contract. This particular process, they preferred to point to California Commercial Code. So I left it in there. Pursuant to California Commercial Code 9210. As a record, now literally I would just take out from this comma to that comma. So enclosed herewith is a request regarding a statement of account as a record authenticated by the debtor requesting that the recipient approve or correct the statement. So-and-so, this is CFO of the bank, hereinafter respondent, has 14 days. Notice how 14 and 14. Okay? Whenever you write a number in digits, make sure that that same number is written in letters and that the digits are in parentheses. Again, this is more style manual stuff. And actually, That should be capitalized.
I was going to ask you. Okay.
Has 14 days to comply with this request and provide an authenticated record. It's private contract, so I don't need that Section 9210 of the Commercial Code. I'm saying, here's a record authenticated by the debtor, and it's custom. This is, now, notice how I'm saying authenticated by the debtor, because who are the only parties who can authenticate the account and the amount owed on the account? The debtor and the creditor. Those are the only two parties that can authenticate a balance due on the account. So you have 14 days to comply with this request and provide an authenticated record. If the request regarding a statement of account is not corrected by the respondent within 14 days, looks like I got it right here.
Quick question, Brandon.
Yeah.
You said authenticated record. How would you know it's an authenticated record?
How would you know it's an authenticated record? What's that?
What are we looking for?
First-hand knowledge, but what would show in form that it's authenticated? Signs it, right? Under penalty of perjury. I declare the following is true, correct, and complete to the best of my knowledge. That alone is that's a private authentication. You put penalty of perjury, that's a public authentication. I don't care what they do, private or public, authenticate it.
You consider a copy of that authenticated letter, or would you need a blue ink signature, in your opinion?
I would prefer a blue ink signature, but if they sent me a copy, I would consider it sufficient. If it had a signature where they declared that it was true, correct, and complete. Now, it's not a genuine record if they sent me a copy. What's that? What if they what?
What if they didn't want to put their signature on it, but they sent you a statement that was...
That's not authenticated. And I don't recognize necessarily the elements of authentication that the public does. So the public may recognize that a typed signature, basically the name typed in, is a authentication. In my private contracts, that is not sufficient. Okay? Excuse me. So if the request regarding a statement of account is not corrected by the respondent within 14 days, then it shall be deemed accepted and or approved. Respondent's failure to respond within 14 days of the postmark of the presentment of this notice of tender for set-off shall cause the principal to have executed a certificate of non-response by the notary public listed below. Said certificate of non-response shall serve as evidence of the respondent's acceptance and or approval of this notice of tender for set-off and the enclosed request regarding a statement of account. Anybody ever received a notice from the IRS? Here's why you got this. Here's what you should do. You notice how they title their sections like that? That's what we're doing. We don't treat our party in contract as idiotic as the IRS likes to, but the IRS is just being real clear on the terms of the contract. Here's why you got it. Here's what you need to do. Here's what happens if you don't do it. They literally entitle their sections like that on the contract. They're making it real clear. We're making it real clear. We're getting their agreement, are we not? That the certificate that comes after this is going to be certifying their acceptance of the statement of account. And it's also going to be certifying the shall serve as evidence respondent's acceptance and or approval of the notice and the request regarding a statement of account.
Do you expect them to send you something back? Or?
No.
No.
And if they do, typically it's not going to be from the guy I addressed. And we will address that. We probably won't get to that today. Is it time for a break? And we probably won't get to that today, but tomorrow we'll show what happens when you're moving through your process and all of a sudden you get something from someone who's not part of the process, but may work at the bank. You know, you're corresponding with the CFO, but you get something from legal counsel or you get something from this guy over here. How do you handle that? You keep moving forward on your process, but you still have to address this guy over here. And actually, if you get something from someone else at that company, it is a blessing, because now you're going to have 2 witnesses to your process and 2 people's agreement to your facts. It's funny, I've actually started to notice they're starting to, because people are becoming savvy to how to do this, they've actually stopped responding so much on your processes with the CFO, because you're getting a double witness as soon as they start. Okay. Yeah, they didn't realize they were actually helping us. They're like, oh, sweet, we got a double witness. So now I got the CFO as a witness, I've got legal counsel as a witness, I've got a notary as a witness, and I got the post office as a witness. Who's got the solid process here? And I don't even have to get my hands on it. I don't have to testify to anything. I got 4 people. I got 4 parties to testify for me.
If you can hold it.
If I can hold it. With first-hand knowledge, indeed. Okay, upon the respondent's acceptance of the request regarding a statement of account, the respondent shall rescind any notice of default, notice of trustee sale, and or trustee's deed upon sale. Notice how this is structured, so it's if you're in default, or they've issued a notice of trustee sale, or they already held a trustee sale. It doesn't matter where you're at in this in the process. This addresses all the points that could be possible. So, upon the respondent's and what symbolizes or certifies their acceptance? Their non-response. So upon their acceptance, which was certified by their non-response, they're agreeing to rescind a notice of default, the notice of trustee sale, and or a trustee's deed upon sale by executing or causing to be executed a notice of rescission regarding the real property commonly known as 101 Main Street, Huntington Beach, California, County of Orange, assessor's parcel number, whatever, hereinafter, collateral, and file said notice of rescission in the office of the Orange County Recorder. Upon the respondent's acceptance of the request regarding a statement of account, the respondent shall also reconvey the collateral to the original trustor of the deed of trust recorded in the office of the Orange County Recorder on or about March 15, 2007 as instrument number blah, 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 by executing or causing to be executed a deed of full reconveyance and file said deed of full reconveyance in the office of the Orange County Recorder. What am I doing? I'm telling them to follow the public. Remember we said, before we started our procedure, we want to know what it looks like in the public, right? And so step 1, right away, we're telling them what we want it to look like in the public. And we're getting their private agreement to have it look this way, right? But we're creditors, right? We're creditors. If they don't perform, what are we going to do?
We're going to do it for them.
We're going to do it for them. So, respondent's failure to execute or cause to be executed the notice of rescission and or deed of full reconveyance within 72 hours of the respondent's acceptance of the request regarding a statement of account shall constitute the granting and conveying of a specific power of attorney by the respondent to the principal for the principal to execute said instruments on behalf of the respondent. In addition, the respondent shall also grant and convey a specific power of attorney to the principal to execute a substitution of trustee and any and all instruments, communications, or correspondences the principal deems necessary for the perfection of the principal's paramount security interest in the collateral. Notice how I just put a catch-all in there? I'm like, you're granting me a specific power of attorney to do all this stuff and anything else I need to do. Right? Respondent shall give notice to the principal of the filing of the notice of rescission and or deed of full reconveyance by mailing certified copies of said instruments to the principal through the notary public listed below. Respondent's failure to give notice to the principal within 72 hours of the filing of said instruments shall be deemed a failure to perform and shall cause the principal to have executed a certificate of non-performance by the notary public listed below. Said certificate of non-performance shall serve as evidence of the respondent's acceptance and or approval of the granting and conveying of the specific power of attorney mentioned above. So what certifies the specific power of attorney? The notary's certification of their non-performance and non-response. That is my specific power of attorney. Any and all responses or notices regarding this notice of tender for set-off and or the enclosed request regarding a statement of account shall be directed to the principal by USPS certified or registered mail at the following address. Service in any other manner will be deemed defective on its face. Executed in Orange County, California Republic, the 6th day of the 4th month in the year of our Lord, 2010. Witness, my hand and seal. Why did I put executed in Orange County, California Republic? This is a private contract executed in the Republic. There are no public protections of limited liability here, my friend. Then it has the name of the principal, secured party creditor, executive trustee for the trust. All capital name letter, all capital name. Enclosures. Always, whenever you have something being carried in under a document like this, always mention or list everything that goes with it. Otherwise, everything after this document isn't there.
Our grammarian suggested that when you have enclosures, you take and make it enclosures as opposed to enclosure and or enclosures.
What?
You got the S on enclosures in parenthesis? He suggested that you make it enclosures as opposed to that way.
Well, in style, if I do not cross out this S, it can be seen as either one, or it can be seen as the plural. You'll notice in notary form, they have in parentheses his, her, them. They'll have in parentheses his, her. It is actually the notary's duty to go through and cross out what is not pertinent. So if I'm dealing with a woman before me, then I'm crossing out him and them. Or I'm crossing out his and their and leaving her in there. Okay?
Anything in parentheses or boxes isn't there anyway.
Again, go to style. Okay? Look to style for this. This is English style. Now, in my enclosures, I have a request regarding a statement of account, which is 1 page. I have a notice to set off accounts. Now, actually, I've changed the format of this to where I have 2, and then I have my cover page, which is evidence of tender for set off of accounts. Again, my process I'll show you tomorrow, which is for another account, but it's the same notice of tender for set off. It's structured slightly different here in the enclosures and in the certificate of service, where there's a title page, which is record of tender for set off. And then under the record of tender for set off, I have the notice to set off accounts, I have the mortgage statement, I have the 1040V, I have the certificate of service for the first presentment, step 1, and then the certificate of non-response that goes to step 1. That's all the record of the tender for set off. And then I have the certificate of service for this process. Okay?
What is your normal time delay between your sending out to the IRS the 3 previous mentioned documents and then your notice of tender for set off to include the certificate of non-response?
I've done it as soon as 1 day after. Because I had one girl who she was on a really tight timeline to get her process in because they were looking to, it was actually an IRS process where the IRS was looking to lien and levy. But we wanted to send the tender over to stop 4440, but we wanted to make sure that the IRS office who sent her the notice of levy got notice that we had sent their payment to another office at the IRS. So I sent it literally, actually I think I might have even done it, no, I did it one day apart. So the first day the notice, or the set-off, the payment went in to Ogden, and then the very next day the notice of it went out to that other office saying, hey, you got your payment, it's over there in Ogden. Okay? This is a request regarding a statement of account. Again, you'll see one tomorrow that's part of another process where I've taken out any and all mentions to commercial code because you don't need it. Okay? So this is who it's to is the CFO of the bank. Who it's from is the executive trustee, okay, or secured party creditor, or whatever designation you give the private trust regarding. This is a request regarding a statement of account on behalf of the debtor and account number, whatever the bank account number is. Request regarding a statement of account pursuant to California Commercial Code. Now, on my new one, it just says, this is a record authenticated by the debtor requesting that the recipient approve or correct the statement indicating what the debtor believes to be the aggregate amount of unpaid obligations secured by collateral as of a specified date and reasonably identifying the transaction relationship that is the subject of the request. Recipient has 14 days to comply with this request and provide an authenticated record. Then you'll see a little title there, Statement of Account.
Brandon?
When I have certification of their acceptance and approval of this, remember you wanted your statement of account? Looky there, and it's got the balance you want on it, and you've got their agreement to it. So now you've got a record of what the statement of account is. We're the creditor. We're not waiting for them to do anything. And you've now got them to grant you a specific power of attorney to execute anything and everything that needs to be executed in their name. So you're not going to go do a reconveyance in your name. You're going to go do a reconveyance in the bank's name. Bank of America is reconveying this property by Brandon A. Adams as attorney in fact for Bank of America. You see? And trust me, documents get executed in the county records every day by attorneys in fact. Almost every document I've ever seen that's been recorded at the county for property is recorded by someone in the capacity as an attorney in fact.
Just like we had a guy in a criminal case. He put in, he was out after he got sentenced. He put in an appeal, his attorney did, and his attorney signed it for his behalf. And when he asked Jack and I, well, I never signed any of appeal, because we told him he had to revoke it because he signed. He said, I never signed it. Did you have an attorney? He goes, yeah, your attorney signed it, so you signed it. He goes, oh, okay. So what Brandon's telling you is when you have an attorney, he's authorized to sign. What you've given yourself there, what they've given you through tacit acquiescence, is their approval for you to be the attorney in fact for this power of attorney. So when you execute it, they executed it, not you. They did. Somebody says, is that your signature? It's the bank's signature.
You see? And remember, you've got evidence of them granting it to you. Well, you will. Not yet. Okay, we're not there yet. We're going to take a break and we'll show you what now gives you the power to execute all the things you need to execute, and then I'll even show you examples of what you're going to execute and file into the public record. And when you're all set, when this is all said and done, you've got a clear account. You've got all on the title side of the public records, it's all in perfect form. Nothing looks out of the ordinary. It all looks just like a regular payoff. And with this complete record, you can go in and do a quiet title if they still got a problem. They still want to push the issue. They still want to try to foreclose. Okay, well, let's go to court. Because I've got a complete record that you have no standing. I've got a complete record that I'm the only one with any standing in regards to this property. I don't need to argue the facts. The facts have all been witnessed by multiple parties. I don't have to assert anything. I've got 4 or 5 witnesses to the facts. Because after I've executed and recorded those county documents, I've now got the county as a witness. I've got the notary as a witness. I got the county as a witness. I got the post office as a witness. How many witnesses does that attorney have? None. He won't bring forward one. And when my evidence, my record by a third party is sitting in chambers in private commerce, and I will explain to you the significance of that, because I had a judge actually come to one of my classes, and he explained the significance of the private side of the court, and it dawned on me why I had had success in the past. Because I had had a success in the past in court. I never showed up to court once. I never filed one thing into the public side of the case. They tried getting a default 6 times and were denied. And finally, the judge dismissed it. And I never showed up. And the judge explained to me why I had success. And I'll explain it to you. And why it's so important to really, more than anything, know how to keep this record and work. Because it's the notary's record that goes into the court, not yours. That's very significant. Okay? So, I think we've finished this process. We'll move on to step 3 after the break. Take a half-hour break. No, again, certificate of service is in here, and since we've already looked at one, they don't change much in form. Do you have a question?
Non-essential items that have to be notarized?
The non-essential...
If there's any non-essential items that have to be notarized, we've been using the notaries that actually work in the court administration. Court administration.
You mean like something like a jurat or an acknowledgement?
Correct. Any non-essential. These are all essentials, but any non-essential item that you want to have notarized that will never be questioned.
That wouldn't hurt, because in that sense, now he's added another witness.
That's right. The court or the city administration notaries are always very helpful. They're never questioned. They're never called a task.
But you'll only get them to notarize acknowledgments and jurats. But you'll have that. As soon as we get into the next step, step 3, we start to move into jurats. Okay? So that's a very relevant point to be making, because now we can bring another witness in. Okay? Yeah, except when you get to the end. The car loan, rather than doing, and also actually that last step where we're talking about reconveyances of deed and things like that, we're not going to be talking about that stuff. We're going to be talking about releases of lien, right, to be filed with the DMV, right? Those are the things we're going to be mentioning in our notice of tender for set-off. And then when we get to the end, rather than executing a reconveyance or notice of rescission, we're going to walk into DMV, execute, release a lien on the vehicle for the bank. Yeah, I'm here for Bank of America to execute a release of lien. Who are you? I'm an attorney in fact for the Bank of America. Right? Yeah. And again, in the public, it's going to be perfect in form. It's going to be seamless. There's not going to be anything out of the ordinary in the public record. It's going to look just like any other payoff. Okay? So we'll take a quick half-hour break. Oh, one more?
Yeah, real quick. It seems like the notary plays a key role in all this. If you don't have a local...
That's an understatement.
Right. If you don't have a local notary, you could probably use somebody from out of state, but then that adds mailing time and so forth, so it'd probably be best to have somebody locally. If you don't have somebody locally, would you recommend that you find a friend who will become a notary, you become a notary, and then you notarize each other's work?
Absolutely. Okay. As long as there's not some kind of partnership between you where your friend would in some way benefit from the execution of your process, because that's a conflict of interest in the notaries. So just keep clean hands in your transactions.
As long as you're not doing any business together, but say you've been friends for 1 year or 10 years, it doesn't matter as long as you... Okay.
It doesn't matter. And really, you can be in business together. It just can't be that whatever they're notarizing, that they're going to benefit from.
They have to be an uninterested party, but all of you that don't have friends that are notaries, get them. Because when you need a notary to do your process, you're going to find a lot of regular public notaries, etc., are not going to do your mailings, or they're not going to cooperate with a protest or a non-response. So please, y'all have friends, have them get some notaries, and we've got a lot of people that don't. So if you just live in the same area, you become a notary. It's not difficult. Matter of fact, I think felons can even become notaries.
No. Oh, yeah, they could.
Yes, they can.
They could. They could.
Some of the states...
You got to be a felon who knows who you are.
Well, there's a couple, the Arizona says, have you been convicted of a felony that would preclude you from doing your job? Well, there's a different kind of a question. So check out your state rules, but get yourself some friends or associates, neighbors, somebody with a notary. Several of them, as a matter of fact, a couple of them, even if you got to buy it for
sessions,
them.
Hereinafter sessions are the private exchange of ideas and concepts between the providers and the recipients. The content is not meant as legal advice. The use or attempted use of any idea or procedure discussed in these sessions, as applied to the recipient's own personal transactions, cases, or controversies, or applied to other cases, may or may not result in a favorable outcome or the same outcome as discussed in these sessions. Each transition or transaction, case, or controversy may be different as a result of unique actions or unique statements made by the parties therein, and each different act or statement in any transaction affects or may affect whether any procedure or idea discussed in these sessions is relevant to the recipient's transactions, or that the outcome thereof will be depicted as in these sessions. The discussion of ideas or procedures in these sessions is not exhaustive of the subjects being discussed. Many ideas and concepts that can affect the outcome of any legal or commercial procedure are not discussed in these sessions, and the fact that recipients may not be aware of these issues may have an adverse effect on the outcome of the recipient's procedures. It is the responsibility of the recipients to understand their own transactions and to apply the appropriate and complete concepts necessary for a procedural and substantive remedy thereto. These sessions may be redistributed privately by any recipient to another recipient requesting them, condition upon the fact that this notice is provided therewith. If you have any questions, you may contact Creditors in Commerce by email at harmony@creditorsincommerce.com.
We left off on step 3. So, step 1, remember, was our tender to the IRS for set off of the account. Step 2, we're basically giving notice and demanding certain levels of performance from the bank based on the tender for set off, right? So step 3, at this point, this process presumes that they haven't performed. Now, if you got your deed of reconveyance, they actually performed on step 2, no need for step 3, okay? However, if they haven't, as creditors, we're not only going to give them a little bit of due process by going into step 2 here, because step 2 is, oh, by the way, you didn't perform. So we're going to give you an opportunity. I'm going to give you 10 more days before this specific power of attorney goes into effect and I start executing this stuff on your behalf. Okay? So, first 2 documents, you'll notice 3.1 and 3.2 are a certificate of non-performance and a certificate of non-response, both of which were mentioned in step 2. So first we'll look at our certificate of non-performance. Okay. So, certificate of non-performance, we have at the top, presentment, be it known that the person signing below, a duly empowered notary public, at the request of John Henry Doe, in care of this address, which is usually the notary's address, did duly present on May 28, 2010, the attached notice of tender for set-off and request regarding a statement of account. Remember, both of those documents had performance duties within them. Request regarding a statement of account had the duty of correcting or approving the statement of account. Did it not? The notice of tender for set-off had duties of issuing or executing a notice of rescission, issuing or executing a statement of account, executing or issuing reconveyance of deed, right? So there are levels of performance on both of these. The notice of tender for set-off and request regarding a statement of account dated May 28th, 2010. 2, name of the CFO, care of the bank, signed by John Henry Doe, demanding performance of the following duties: to give notice of and execute or cause to be executed a notice of rescission and deed of full reconveyance, the time limit having elapsed for timely performance thereto. Default, whereupon the notary public signing below, for the reason dishonor by non-response / non-performance, does publicly and solemnly certify the dishonor is against all parties it may concern by reason of non-response, non-performance thereof, and stipulations therein. Notice, the undersigned notary public certifies that on June 30th, notices of fault were sent to the parties noted below by depositing in a depository of the United States Postal Service within the state indicated herein a sealed envelope containing said notices directed to the respective persons or entities at the last known corresponding addresses noted below. Has the name and address of the recipients of our notice of fault. Notice of fault is 3.3. This is document 3.1. The certificate of non-response is document 3.2. And our notice of fault, which we're saying is being mailed out the same day that we're executing this certificate. Am I mailing this certificate? No. I'm just putting in the certificate that a notice of their non-response, non-performance in the form of a notice of fault is being issued and mailed.
Is it your intent to call it a default as you do in the second to the last paragraph as opposed to fault?
Yep. Testimony. In testimony of the above, I have signed my name and attached my official seal. And then you have the notary signature, commission expiration, and the date of execution of this document. So now we're going to look at the certificate of non-response. Certificate of non-response. Presentment. Be it known that the person signing below, duly empowered notary public at the request of John Henry Doe and care of the notary's address, did duly present on, should be the same date as the last one. But like I said, these documents are all thrown together. So May 28th, the attached notice of tender for set-off and request regarding a statement of account dated May 28th. 2, CFO of the bank, care of the bank's address, signed by John Henry Doe, requesting correction or approval of the statement of account. Remember, in our notice of tender for set-off, we said that a certification of their non-response would be deemed acceptance or approval of the request regarding a statement of account. So, default, whereupon the notary public signing below. Wait. Let me finish that statement up above. Requesting correction or approval of statement of account. The time limit having elapsed for a timely response thereto. Default, whereupon the notary public signing below, for the reason of dishonor by non-response, does publicly and solemnly certify the dishonor is against all parties it may concern by reason of non-response thereof and stipulations therein. Testimony. In testimony of the above, I have signed my name and attached my official seal. Boom. Document 3.3, our notice of fault. Same statement at the top. This is private communication between the parties. Notice to agents, notice to principal, notice to principals, notice to agent. I call this a notice of fault and dishonor, opportunity to cure. Dated June 30th, has the same principal and respondent information, and it also has reference to the account. Statement of facts. So this is actually, this notice of fault, opportunity to cure, is in the form of an affidavit. On May 28th, John Henry Doe, hereinafter principal, made presentment of a notice of tender for set-off and a request regarding a statement of account, hereinafter presentment, via so-and-so, notary public, hereinafter notary. 2, chief financial officer guy, hereinafter respondent. On June 4th, 2010, United States Postal Service, hereinafter carrier, successfully delivered the presentment to the respondent. As of June 25th, 2010, respondent has not sufficiently responded to the presentment. On June 25th, 2010, principal made presentment of a notice of fault in dishonor. Okay, this again, this is where critical thinking comes in. When I authored this process, it was correcting a notice of fault that had already been sent in. So you would actually eliminate this line, number 3, because it says right here on June 25th, 2010, principal made presentment of notice of fault and dishonor. Wait a minute, aren't we making presentment of a notice of fault right now? Opportunity to cure, hereinafter, defective fault notice. Said presentment contained defects and is hereby rescinded. You see how contracts are fluid and dynamic. Oh my God, I made a mistake in my process. Okay, correct it. I just corrected it. Respondent's failure to sufficiently respond or timely honor the presentment, we're still talking about step 2, by the terms of the presentment, constitutes respondent's acceptance and approval of the request regarding a statement of account contained therein. Respondent's failure to perform by the terms of the presentment constitutes respondent's acceptance and approval of the granting and conveying of a specific power of attorney to the principal to perform the duties of the respondent stipulated therein. Number 6, respondents are at fault. Number 7, as an operation of law, the respondent by dishonor of the presentment has created a fault. Opportunity to cure. In the event that the respondent's failure to respond to the presentment was an oversight, mistake, or otherwise unintentional, principal grants respondent 10 days, exclusive of the day of receipt, to cure the fault and effect the remedy. The respondents have 10 calendar days to cure their dishonor by the following. 1. Correct the statement of account contained within the request regarding a statement of account by the terms stipulated therein. Remember the terms? A verified statement of account they must sign. Number 2, execute or cause to be executed a notice of rescission. Now notice, 1 or 2. Why or? Well, because if they actually do correct it and sign under penalty of perjury that it is something other than 0, well then I can't really demand they execute those other documents, right? So they're either going to execute a new statement of account, or they're going to agree that it's 0 and do these other duties, perform these other duties, duties. So they will execute or cause to be executed a notice of rescission and a deed of full reconveyance in accord with the presentment and pursuant to the deed of trust recorded on or about November 3rd, 2005 in the Office Los Angeles County Recorder as instrument number blah, blah, blah. I'm basically telling them, perform by the trust we originally created. Remember, the trust said, when I pay you off, you're going to reconvey the deed. You've been paid. Stop breaching the contract. Right? Who's in breach here? They are. So we're saying not only by this new agreement that's been established by the last couple of presentments, but pursuant to the original deed of trust or mortgage agreement. You said you were going to perform this way. Failure to cure will constitute, as an operation of law, the final admission of the facts set forth in the presentment by the respondents through tacit assent to the presentment, and the whole matter shall be deemed res judicata and stare decisis. What does that mean? It is already decided. They will be admitting all the facts contained in our initial presentment and all the facts contained in this presentment. Nothing else can be decided. There is no arguing these facts if they fail to respond.
Res judicata is against the world.
It's against the world?
Yeah.
What do you mean?
When it's deemed res judicata, it's deemed against the entire world. It's a cool statement, in other words. You did a nice thing there.
Response by respondent must be served on principle exactly as provided. John Henry Doe, care of the notary, and notary's address. Now notice here, again, double witness to the jurisdiction I am executing this document in. Remember, top of the document said this is private, right? Now I'm going to put on here a commercial affidavit, oath, and verification. I, John Henry Doe, secured party creditor, under my unlimited liability and commercial oath, proceeding in good faith, being of sound mind, having first-hand knowledge, affirm, state, and declare that the facts contained herein are true, correct, complete, and not misleading, under penalty of international commercial law, so help me God. This 30th day of the 6th month in the year of our Lord 2010, witness my hand and seal. Then here comes the jurat.
What's the difference between the notary and the jurat?
The notary is a person. A jurat is a statement made by the notary.
Okay.
A jurat, you mean a jurat and an acknowledgement?
Yeah.
An acknowledgement is merely I'm acknowledging who signed the document. A jurat is the notary is actually administering that oath you just took above. See, the notary also has the power to administer an oath. Okay? An oath under a witness takes on a new level of significance and power, in that an oath taken by yourself doesn't have that much weight to it, but an oath taken in witness of someone else is, what's the word rather than irrefutable? Dispositive. Okay? So they're acting as a witness to as the administrator of the oath.
Yeah, dispositive is that which cannot be challenged.
Okay? So we're right here, you notice in the wording, subscribed and sworn to or affirmed before me on this date by the principal, proved to me on the basis of satisfactory evidence to be the person who appeared before me. So they're doing, not only are they testifying that you subscribed, sworn, or affirmed the statement and made an oath, they're also subscribing that you're the person. So whereas an acknowledgement is merely saying this is who showed up and executed the document. A jurat is saying this is who showed up and I administered an oath to them. That's the significant difference between a jurat and an acknowledgement. Okay. Enclosures. Attachment A. Record of presentment consisting of A. Notice of tender for set-off. B. Request regarding the statement of account. C. Notice to set off accounts. D. Mortgage statement of account, money order. E. IRS Form 1040. F. Certificate of service. G. Certificate of non-response. H. Certificate of service for step 2. So remember, this certificate of service is a certificate of service for step 1. This certificate of service is a certificate of service for step 2. And I'm going to include the USPS Form 3806, receipt for registered mail, and the USPS Form 3811. I've now brought all my witnesses in. Right? Not only the notary, but the post office. I've now included all the records. And the certificate of service for this presentment. So this is a 3-page notice of fault. This is the cover page, attachment A. It's like the cover page serves as like a table of contents of the record that follows it. So it's much like what was listed on the enclosures part of the first page, but it says right here, attachment A, giving it the title, designation, a inference or a distinction of this attachment being record of presentment, and then underneath that, subheading 4, notice of fault and dishonor, opportunity to cure, number, and that's the registered mail number of the notice of fault, opportunity to cure. This section, attachment A, includes, and then it lists 1 through 11, all the items and the number of pages of each item. This section includes a total of 14 pages, not inclusive of this page, the title page. So in all, it's 15 pages. So I've got a 3-page notice of fault and 15 pages in addition. So how many total pages? 18. Plus there's going to be certificate of service. So if the certificate of service is 1 page, how many total pages? 19 pages. 19 pages. Okay? Notice how I've even broken down in the certificate of service attachment A, record of presentment, and then all the elements of the record of presentment are sub-categorized under number 2, attachment A. So I've got number 1, the notice of fault. Number 2 is the record. And in the record are all these elements, A through K. And then number 3 is this certificate of service. Okay? That is our step 3. What is the purpose of step 3? Opportunity to cure, a second witness to all the facts, presentment of the record of everything that's happened up until that point. Have we not? So this is our due process. So, what do you think step 4 might be? Whoa, 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 there ain't even a court case yet, my friend. What typically comes in due process? What comes after a notice of fault?
Notice of default and dishonor.
What else will be included in there?
The entire record.
What else? What else happens? Not what's going to be included with the default, but what else is going to happen in step 4?
Consent to judgment.
That's part of the notice of default. What other documents get executed? Are we going to certify their non-response to the notice of fault?
Yep.
Okay. So step 4, we're going to have a certificate of non-response. Then we're going to have our notice of default. The certificate of non-response is certifying their non-response to the opportunity to cure. Step 3.
Excuse me, Brandon.
I keep forgetting that I already had these all open. Yeah.
On your that flyer there behind you, are we still in step 2, perfect interest and title, or have we moved into effect remedy?
We're still in settling the account.
We're still in settling that? Okay. All right, thank you.
Step 5, we get into perfecting interest and title.
Okay, and then step 6 is the following one?
If you've already got possession, there's nothing to do for step 3.
Okay, great. Thank you.
So here we have I actually entitled this Certificate of Non-Response / Non-Performance because the notice of fault is still demanding a level of performance, is it not? Remember, their opportunity to cure was some form of performance, was it not? Okay, so now I'm certifying their non-response, therefore agreement to the facts. Because remember, notice of fault was an affidavit, right? If they don't respond to an affidavit, are they not in agreement with all the facts? Okay, so I'm certifying both their agreement to all the facts contained within the notice of fault, and I'm certifying their lack of performance or failure to perform the 2 points that we gave them within that opportunity to cure. We gave them 2 possible ways of performing. So, again, typical language all the way down to what the presentment was made of a notice of fault and dishonor opportunity to cure. What was it requesting? Curing fault by stipulated performance or correcting statement of account, right? Because those were the 2 forms of performance, remember? We said, number 1, correct the statement of account, or number 2, execute all the stuff we told you to execute in step 2, or in their eyes, step 1, which was the notice of tender for set-off. We were basically saying, execute notice of rescission, execute reconveyance of deed, execute, whatever we told them to execute. That was the other form of honor. And then we're saying down here under notice, the undersigned notary public certifies that on the date of the execution of this certificate, that a notice of default were sent to the parties noted below by depositing United States, blah, 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 blah. Okay, so you notice that each of these certificates, the language changes, guys, not just what's in the field boxes there. So this particular certificate is really only relevant because of this language here after a notice of fault, because it's making reference that a notice of default is being sent out. What's that? Oh, shoot. Yeah, there's an F missing. Again, you better read this stuff. What the hell? Oh, Garrett's on it. I'm like, what's going on here? Hit Control S. Okay. So that is what? 4.1. So we need 4.2, notice of default. Notice of default, much like notice of fault, is in the form of an affidavit. I call this notice of default in dishonor consent to judgment. What kind of a judgment? Administrative judgment. They are consenting to judgment at this point. And, of course, it's private. Every step of the way, private. We have our principal and respondents at the top. Here's our statement of facts. On April 23rd, 2010, principal, or actually, this particular process was being executed by one party on behalf of another party. And you guys can rewrite your processes such that, oh, I want to go help so-and-so do their help with their house, but they don't know what the hell they're doing. So I get them to execute a commercial security agreement, making me the paramount security interest over their stuff. Right? So now I can go execute anything and everything I need to because we have a private agreement where I have control over their set-off account, their private trust account, their property, their straw man's property, their birth certificate, everything that is a part of their public trust, they're going to grant and convey to me the paramount security interest. And now I can be the principal, but in this case, someone else was the trustor on the deed of trust. Now, if it was your straw man that was the trustor on the deed of trust, then it would be the name of your straw man. Okay? So on June 23rd, 2010, so-and-so, hereinafter trustor, made presentment of a notice to set off accounts, mortgage statement of account, and money order. See, in this particular process, the step one was done under the party you were helping, right? Because you're using their set-off. Because it's their obligation. Now, I've actually successfully set off other people's debt with my private asset account. I had a friend who had a state board of equalization debt for $90,000. I used my private exemption and set off the debt. Now, it was a corporation's debt. I don't know necessarily that it would work if it were a U.S. citizen's debt, because there's a different designation. A U.S. citizen has its the authority of its creation isn't the state of California, but this particular, when I was doing it for this corporation, it's a corporation. Anyone can set off its debt. You know what I mean? So I don't know if that's why it worked, and it may not work, but because we're unsure, we just said, okay, we'll have her do the set-off. And then, since I've got the paramount security interest in all her property, I'm going to execute step 2 through 5. Because she's not competent. Okay? So, hereinafter trustor made presentment of step 1, which was our tender for set off. Hereinafter tender, a record of which is attached hereto and incorporated herein in its entirety as attachment A. To IRS Technical Support Division, hereinafter tender agent for the set-off settlement and closure of account number, hereinafter account, sent via USPS register mail, article number, blah, 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 by Notary Public, hereinafter notary, as evidenced by Notary Certificate of Service, dated, a record of which is attached hereto and incorporated herein in its entirety as attachment A. Number 2, on May 3rd, 2010, United States Postal Service, hereinafter carrier, delivered the tender to the tender agent. Number 3, on May 28, 2010, the tender agent accepted the tender for the settlement of the account, as evidenced by the certificate of non-response dated May 28, 2010, record of which is attached here too as attachment A. Number 4, on May 28, 2010, John Henry Doe, hereinafter principal, made presentment of a notice of tender for set-off and a request regarding a statement of account, hereinafter presentment. 2, John Jones, Chief Financial Officer, ABC Bank, hereinafter respondent, sent via USPS registered mail article number by the notary, as evidenced by notary certificate of service dated May 28, 2010, a record of which is attached here too as attachment A. Number 5, on June 4, 2010, the carrier delivered the presentment to the respondent. On June 30, 2010, respondent accepted the terms and provisions of the presentment as evidenced by the certificate of non-response dated June 30th, record of which is attached here too as attachment A. Number 7, respondent's failure to sufficiently respond or timely honor the presentment by the terms of the presentment constitutes respondent's acceptance and approval of the request regarding a statement of account contained therein. Number 8, as of June 30th, 2010, neither the principal nor the notary have received sufficient response to the presentment. You see why I define all these things? Can you imagine me writing out everything that is the notary, the principal, the presentment, you know? That's why we define these things here and after this, so that I don't have to write all of that. I mean, this paragraph would be 3 times as long if I didn't predefine a lot of these words. So we want to say as much as we can and be as concise as possible. So, as of June 30th, 2010, neither the principal nor the notary have received sufficient response to the presentment, thereby placing the respondent at fault, as evidenced by the certificate of non-response dated June 30th, 2010, and the certificate of non-performance dated June 30th, 2010, record of which is attached here too as attachment A. Number 9, on June 25th, 2010, principal made presentment of a notice of fault and dishonor opportunity to cure to the respondent, dated June 25th, 2010. Hereinafter, defective fault notice. Remember, this process, there were 2 notices of fault sent out. One was defective. Sent via USPS registered mail, article number, blah, 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 by the notary. Said defective fault notice contained defects and is rescinded as of June 30th, 2010. On June 30th, 2010, principal made presentment of a notice of fault and dishonor opportunity to cure to the respondent dated June 30th, 2010, hereinafter corrected fault notice, a record of which is attached here too as attachment A, sent via USPS registered mail, article number, blah, blah, blah. Notice how I did include a copy of the defective one, but I did include a copy of the corrected one. Hereinafter corrected fault notice, a record of which is attached here too as attachment A, sent via USPS registered mail, article number, blah, 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 by the notary, as evidenced by the notary's certificate of service dated June 30th, a record of which is attached here too as attachment A. Number 11, as of July 12th, 2010, neither the principal nor the notary received sufficient response to the presentment or the corrected fault notice from the respondents, as evidenced by the certificate of non-response / non-performance dated July 12, 2010, record of which is attached here too as attachment A. Number 12. Oops, a little too far. Respondent's failure to perform by the terms of the presentment constitutes respondent's acceptance and approval of the granting and conveying of a specific power of attorney to the principal to perform the duties of the respondent stipulated therein. Number 13, respondent's failure to perform by the terms of the corrected fault notice constitutes respondent's acceptance and approval of the granting and conveying of a specific power. It's basically, I'm outlining the double witness of them granting and conveying the specific power of attorney. So, respondent's failure to perform by the terms of the corrected fault notice constitutes respondent's acceptance and approval of the granting and conveying of a specific power of attorney to the principal to perform the duties of the respondent stipulated therein. 14, respondent's failure to sufficiently respond or timely honor the corrected fault notice by the terms of the corrected fault notice constitutes respondent's acceptance and approval of the request regarding a statement of account incorporated with the presentment. Number 15, respondent's acceptance and approval of the request regarding a statement of account constitutes respondent's agreement to the stipulated aggregate amount of unpaid obligation being $0. Number 16, respondent has defaulted. Number 17, as an operation of law, respondent by dishonor of the presentment and corrected fault notice has created a default. Oops. Default. For the respondent's failure to honor the presentment and corrected fault notice places the respondent in default. For the course of dealing set forth herein, with the respondent's failure, refusal, or neglect in the presentment of a verified response to the presentment and corrected fault notice constitutes the respondent's failure to perform in good faith and the respondent's acquiescence in tacit agreement with all terms, conditions, and stipulations set forth within the notice of default and dishonor consent to judgment, the presentment, and the corrected fault notice. Therefore, this matter is deemed res judicata and stare decisis. Of this presentment take due notice and heed, and govern yourself accordingly. This final expression in a record is intended as a complete and exclusive statement of the terms of the agreement between the parties. And then we have here my commercial affidavit and oath. I, John Henry Doe, secure party creditor under my unlimited liability and commercial oath, proceeding in good faith, being of sound mind, having first-hand knowledge, affirm, state, and declare that the facts contained herein are true, correct, and complete, and not misleading, under penalty of international commercial law. So help me God, this 12th day, the 7th month, in the year of our Lord, 2010. Witness my hand and seal. And then, of course, I've got my jurat. What's a jurat? Statement of the notary of what? Of the giving of an oath, right? Enclosures, attachment A, record of presentment and fault notice consisting of A through Q. And you see in there all the elements including the certificate of non-response / non-performance, which was to the notice of fault, right? So, certificate of non-response, non-performance, certificate of non-response to step 2, certificate of non-performance to step 2, the notice of fault and dishonor, opportunity to cure, which was step 3, the request regarding a statement of account, the notice of fault was step 3, notice of tender for set-off, which was step 2, the request regarding a statement of account, which was in step 2, certificate of non-response to step 1, the notice to set off accounts, which was in step 1, the mortgage statement and account money order, which was in step 1, the IRS Form 1040, which was in step 1, the certificate of service from step 1, the USPS Form 3806, return for registered mail, which was from step 1, certificate of service from step 2, the USPS Form 3806, return for registered mail, receipt for registered mail from step 2, 3811 from step 2, notary certificate of service from step 3, and the USPS form from step 3, and the certificate of service for this presentment. That's a complete record. This, in its entirety, including one more document, would be what you would submit. Actually, 2 more documents, because you're going to do one more certificate on this process. Even though, are we asking for a response? Nope. But what was it entitled? Notice of default and dishonor. Consent to judgment. So what am I going to be certifying? Their consent to the judgment. And since I didn't ask for a response, what am I going to use for a response time? A seasonable, reasonable amount of time. Okay? Okay. Okay, this is our... all right. Okay, this is our attachment A, record of presentment and fault notice. So this is for the notice of default and dishonor consent to judgment number, and there's the registered mail number of this particular presentment, and then indexed is everything in our record. This section includes a total of 22 pages, not inclusive of this page. Then here's our certificate of service, and this is probably a 2-pager, I imagine. Indeed it is. 28 pages total. So there is almost our complete record. That was step 4. Okay? Oh, you saw the box? You guys want to read the box?
Creditors in Commerce workshop sessions, hereinafter sessions, are the private exchange of ideas and concepts between the providers and the recipients. The content is not meant as legal advice. The use or attempted use of any idea or procedure discussed in these sessions, as applied to the recipient's own personal transactions, cases, or controversies, or applied to other cases, may or may not result in a favorable outcome or the same outcome as discussed in these sessions. Each transition or transaction, case, or controversy may be different as a result of unique actions or unique statements made by the parties therein, and each different act or statement in any transaction affects or may affect whether any procedure or idea discussed in these sessions is relevant to the recipient's transactions or that the outcome thereof will be depicted as in these sessions. The discussion of ideas or procedures in these sessions is not exhaustive of the subjects being discussed. Many ideas and concepts that can affect the outcome of any legal or commercial procedure are not discussed in these sessions, and the fact that the recipients may not be aware of these issues may have an adverse effect on the outcome of the recipient's procedures. It is the responsibility of the recipients to understand their own transactions and to apply the appropriate and complete concepts necessary for a procedural and substantive remedy thereto. These sessions may be redistributed privately by any recipient to another recipient requesting them, condition upon the fact that this notice is provided therewith. If you have any questions, you may contact Creditors in Commerce by email at harmony@creditorsincommerce.com.
What we're going to do is discuss taking control of property, which isn't exclusive to real property. We could be talking about vehicles or anything else. Okay?
Understand when he talks about real property, speaking of real estate as opposed to movable goods like a car or something. So real property is different than movable goods.
Okay. So there's 3 elements to perfection of a security interest. Okay? If there's an outstanding liability or an account, the account must be settled. The title, documents of title, must be clear in that they show the only lien holder to be you or the party who is perfecting the security interest. 3, possession. You control through possession. If you control through title and possession, then you have what's called a perfected security interest. Okay? So let's first take a look at settling the account. We were just discussing, or we've been discussing over the last couple months, using IRS Technical Support Division for settling accounts. How many are familiar with those processes? Okay, not everybody's familiar with them? Okay. So those of you not familiar, we've done sessions, actually the February session of the Living Temple, we went into detail on settling accounts using A for V. Now, if it's real property, I would probably use a bonded promissory note, but to use bonded promissory notes, you must have established your account with the Treasury, meaning you've done the BC bond with the birth certificate accepted for value, you've done indemnity bonds, set-off bonds, and then you can issue bonded promissory notes off of the set-off bond, okay? If you haven't done that, then you may be looking at getting some kind of a statement. If it is a statement with a coupon, that's preferable, and then doing the A for V process that we've discussed in the past. Now, because of the nature of property being that if you go into dishonor on the account, it's going to escalate with the lien holder a process whereby they're going to attempt to perfect a security interest by possession of your property, meaning they're going to try to take it away. Right?
Hey,
You stop paying your car payment, what's going to happen? They're going to take it away. If you stop paying for your house, what are they going to try to do? Take it away.
Might be important for you all to clearly understand what a security interest is, because he's using that word a lot. And a real simple definition for you is a lien on personal property created by an agreement. So when he's talking about a security interest, try and replace that with that definition. Might give you a little better understanding.
Say that again.
A lien on personal property created by an agreement.
Okay? So, the first presentment we're going to make is going to be in this particular.
Hi, this is Bezel Bay, and today you'll be enjoying Wtdta Radio, where we'll be exploring the world of accounting, current expected credit loss provisions, estate planning, and tax planning, just to name a few. Don't forget, in the evening session, we'll be definitely going into civics and syntactical trust. So remember, if you listen long enough, you will definitely learn something. Peace and love, family. Peace and love.
Creditors in Commerce workshop sessions, hereinafter sessions, are the private exchange of ideas and concepts between the providers and the recipients. The content is not meant as legal advice. The use or attempted use of any idea or procedure discussed in these sessions, as applied to the recipient's own personal transactions, cases, or controversies, or applied to other cases, may or may not result in a favorable outcome or the same outcome as discussed in these sessions. Each transition or transaction, case, or controversy may be different as a result of unique actions or unique statements made by the parties therein, and each different act or statement in any transaction affects or may affect whether any procedure or idea discussed in these sessions is relevant to the recipient's transactions, or that the outcome thereof will be depicted as in these sessions. The discussion of ideas or procedures in these sessions is not exhaustive of the subjects being discussed. Many ideas and concepts that can affect the outcome of any legal or commercial procedure are not discussed in these sessions, and the fact that the recipients may not be aware of these issues may have an adverse effect on the outcome of the recipient's procedures. It is the responsibility of the recipients to understand their own transactions and to apply the appropriate and complete concepts necessary for a procedural and substantive remedy thereto. These sessions may be redistributed privately by any recipient to another recipient requesting them, condition upon the fact that this notice is provided therewith. If you have any questions, you may contact Creditors in Commerce by email at harmony@creditorsincommerce.com.
What we're going to do is discuss taking control of property, which isn't exclusive to real property. We could be talking about vehicles or anything else. Okay?
Understand when he talks about real property, speaking of real estate as opposed to movable goods like a car or something. So real property is different than movable goods.
Okay. So there's 3 elements to perfection of a security interest. Okay? If there's an outstanding liability or an account, the account must be settled. The title, documents of title, must be clear in that they show the only lien holder to be you or the party who is perfecting the security interest. 3, possession. You control through possession. If you control through title and possession, then you have what's called a perfected security interest. Okay? So let's first take a look at settling the account. We were just discussing, or we've been discussing over the last couple months, using IRS Technical Support Division for settling accounts. How many are familiar with those processes? Okay, not everybody's familiar with them? Okay. So those of you not familiar, we've done sessions, actually the February session of the Living Temple, we went into detail on settling accounts using A for V. Now, if it's real property, I would probably use a bonded promissory note, but to use bonded promissory notes, you must have established your account with the Treasury, meaning you've done the BC bond with the birth certificate accepted for value, you've done indemnity bonds, set-off bonds, and then you can issue bonded promissory notes off of the set-off bond, okay? If you haven't done that, then you may be looking at getting some kind of a statement. If it is a statement with a coupon, that's preferable, and then doing the A for V process that we've discussed in the past. Now, because of the nature of property being that if you go into dishonor on the account, it's going to escalate with the lien holder a process whereby they're going to attempt to perfect a security interest by possession of your property, meaning they're going to try to take it away, right?
Hey,
you stop paying your car payment, what's going to happen? They're going to take it away. If you stop paying for your house, what are they going to try to do? Take it away.
Might be important for you all to clearly understand what a security interest is, because he's using that word a lot. And a real simple definition for you is a lien on personal property created by an agreement. So when he's talking about a security interest, try and replace that with that definition. Might give you a little better understanding.
Say that again.
A lien on personal property created by an agreement.
Okay? So, the first presentment we're going to make is going to be, in this particular model, this is not the only way. How many ways are there?
375,000.
Okay. So this is one way. Because of the nature of property, I'm not going to just send in my payment instrument or my tender for set-off to Technical Support Division of IRS. I'm going to make it a process. Now, it's not a three-step process, meaning I'm not going to be doing notice of fault, notice of default, or anything with the IRS Technical Support Division, because there's only really one thing I expect, or two possibilities that I expect the IRS to do. They're either going to, one, return the payment instrument and identify a defect in it, or two, they're going to accept it. And they have 10 days to do either. Okay?
Why do you pick 10 days?
I picked 10 days because in private contract, 72 hours is perfection of the contract.
So you're allowing 3 days for mailing, 3 days for the contract, 3 days for mailing back on a Sunday.
Exactly.
So that comports with commercial law and keeps us safe.
Exactly.
So shorter time would not be fair dealing, would it?
No, it would not. Unless you were using a method like having someone walk into the Technical Support Division of IRS and make presentment of your tender for set-off, then you could do it with, minimum 6-7 days. Or if you did express mail and it got there the very next day, maybe 6-7 days. But in reality, at least 10 days. And if you're sending registered mail, really you're looking at 14 to 20 days, depending on how long it takes your registered mail to arrive at the Technical Support Division of IRS.
Because registered mail goes from hand to hand to hand, and so registered mail actually takes longer than first class, certified, overnight, and everything else, so they really don't have it until it gets there, does it?
Right. Okay? So once I've done, and what I do to make this a process is, of course, if I was going to do A for V, I would do the same thing as if I were doing any other A for V through the Technical Support Division, where I accept for value the statement, turn the coupon into a money order for the full amount of the outstanding balance on the account. If I were tendering a bonded promissory note, I would make the bonded promissory note at least 125% of the outstanding balance. Meaning, if I owe $1 million on the property, I'm going to make the note for $1,250,000.
Why?
Such to cover any penalties, interest, or fees that are unknown by me. See, when we do the A for V, the language I use on the A for V is it tells the IRS that set the balance to zero, basically. So even if there's a face value to the money order, I include a 1040V with a blank amount on it and a special endorsement on the back of that 1040V, so that if there are any additional fees, because the IRS needs to collect a fee for performing the service. And the money order itself made off the statement isn't necessarily going to cover the fees that the Treasury would collect for the service of setting off the account. If there's any additional interest or penalties that exist that are not given or shown on the statement, then the IRS has, because they've been instructed to set the balance to zero, that blank 1040V, and when I say blank, I mean just the amount box on the 1040V is blank. The rest of the 1040V has the taxpayer information in it, and there is a special endorsement I put on the back.
Quick question to back up. You talked about registered mail. Does it need to go registered mail? Because I'm a little confused. Could it go certified mail by the notary?
It can go certified because on this particular presentment, I'm doing it through a notary because I want a record of this presentment.
What about a CFO if I'm sending one to the Visa card CFO and I use a notary presentment? Do I need to use registered, or would I be okay with certified?
You're okay with certified. However, whenever you send an instrument, like a bonded promissory note, use registered.
So if I was sending the bonded promissory note to the IRS Tech Support Division, or I was sending it to the CFO or to the CFO of the court, that's when I want to use registered mail. Or if I was sending a private record, maybe to the judge, but it didn't have a financial instrument, I would be fine sending to the judge via certified mail. But if there's a financial instrument, that's when I want to use registered mail.
Absolutely. I actually, whenever I'm presenting anything into the private side of judges' chambers, I always send it registered, whether or not there's an instrument in it or not.
So it's just a good idea. I just want a little clarity there, that's all.
Yeah. So now that we've made the first presentment, and remember, because it's a presentment, it's going to have a certificate of service so that the notary is keeping a record of what's being presented. And I also include with that what I call a notice to set off accounts, which is basically telling the IRS, take this tender and set off this account.
Isn't that just essentially an offer?
Yeah. But I'm also instructing them that if there's a defect in the instrument, return the instrument within 10 days. Otherwise, they agree to set off the account.
You're doing that in the cover letter, right?
Yeah, the cover letter I call a notice to set off accounts.
Even with the A for V.
Even with the A for V. Okay? Now I've got a record. Once the 10 days has passed from their receipt of it, or 7 days from their receipt. Why am I saying their receipt of it?
Is not receipt defined as when it's put in the mail?
I'm saying their receipt of it as the USPS reports the delivery of it.
Okay.
So from delivery. Okay? The reason is because register mail, unknown. It could take 3 days. It could take 8 days. If it takes 8 days, really giving them 10 days is not sufficient. Okay? So I check on the USPS website. This ink's going to make me sneeze.
And that's called USPS Track and Confirm on your computer, and it'll bring it right up.
USPS.com. You can track the register mail number, and it'll give you when it's been delivered. Then I'll give them at least 7 to 8 days from that point to respond or return the instrument identifying a defect in the instrument. After the time has lapsed, the notary will then certify their non-response. I have a certificate of non-response that the notary then issues, and we keep the originals of that certificate of non-response. I don't send anything else to IRS Technical Support Division. If they haven't sent me anything, then they're in agreement to set off the account.
So you don't send like a notice of fault in conjunction with a certificate of non-response?
Nope. I don't send them, and you never send them the certificate of non-response. That is your record. That's not something you send out.
The notary will give it to you.
Exactly.
So you don't even notify the IRS of their fault?
They're not in fault. They're not in fault because why? They had two options.
They didn't respond in 10 days.
Right. They had two options. Acceptance, which means you just do nothing, or return it with a defect. If they didn't return it with a defect, what happened? They accepted it. Okay? So now that they've accepted it, I can get my record from the notary of the non-response. Now, that certificate of non-response, along with a copy of everything that was sent and the original certificate of service, is a record of acceptance of the tender for set-off, right? Okay. I now take copies of that record, okay? A copy of the certificate of non-response, a copy of the certificate of service, the executed certificate of service with the signature on it, and a copy of the presentment, which would have been my notice to set off accounts, and either a copy of the bond and promissory note or a copy of the A for V and money order and a copy of the 1040V. Okay? I take that record and I put a notice with that called a notice of tender for set off. And I'm sending that to the CFO of the bank. Along with the record and the notice of tender for set-off, I'm sending them a request regarding a statement of account. If you want to see the details of a request regarding a statement of account, go to UCC Title 9, Section 9210. Or 9-210. Okay? The request regarding a statement of account is relevant to collateralized debt. And inform what it is a request to the CFO on behalf of the debtor, identifying the collateral and the account number, and it has on it the debtor's version of the statement of account, meaning the debtor believes that this account is now a zero balance account, right? So the statement of account will also have on it the balance, which, because we've tendered for set off, the balance is zero. And it's signed. It's a verified document, meaning it's signed under penalty of perjury, something along those lines, okay? Now, under 9210, you must give them 14 days. And the only way the CFO can respond to a request regarding a statement of account is with a verified statement stating that it is something other than what the debtor has alleged the debt to be. So if the debtor is saying that the balance is zero, the CFO must respond with a statement of account stating that it is something other than zero, and they must sign it under penalty of perjury.
Is that noticed in your original request when you sent it in to the CFO?
Is what?
Is that notated on your original?
That they have 14 days?
Correct.
Yes, it is.
And you have a sample of that?
I have a sample of that, yeah. A request regarding a statement of account. In fact, I think in Section 9210, they have a example of it too. Either that or they have in there what's required to be on it, okay? And my example has everything that's required to be on a request regarding a statement of account, including, it's one of the few UCC sections that requires a reference to that section number.
Do you put that in brackets?
I put it in, it may be in brackets, I forget, but it's in there stating that, but because they basically state that it's required to put the UCC section number, I put that in there that pursuant to UCC section 9-210, this is a request regarding a statement of account allowing the alleged creditor to respond within 14 days to the balance shown herein. Okay, that's not the exact language, I'm paraphrasing, but it's basically something along those lines. So, notice of tender for set-off, request regarding statement of account, and a record of the tender itself, which included all the elements of everything I sent to Technical Support Division plus the certificate of non-response. Okay? Once the 14 days has passed, my notary is then going to certify their non-response. Okay? Now, I could do a due process on this particular part, doing a notice of fault, opportunity to cure, but in reality, the request regarding a statement of account, I don't need to do a due process on. If they don't respond within the 14 days, it's established that the balance on that account is now zero.
Because you offered that as an offer that to your records it's zero.
Mm-hmm.
If they don't contest that, it's automatic.
Exactly. But me personally, I would probably do the 3-step process on this. I would probably, because really, this is a claim. And whenever you have a claim, you want to have due process with your claim.
Due process?
Due process is the full 3-step process, meaning step 1, which we just discussed, step 2, notice of fault, opportunity to cure, and step 3, notice of default.
So essentially step 1 might be notice, private, international remedy, demand,
could be
payment, fault, dishonor.
Exactly.
Okay.
So once I've done that and I've gotten my certificates of non-response for each of those steps, that is now a complete record of what? What have I established with that record? The account balance is zero. Pretty cool, huh?
Or is it closed?
It's not closed. The balance is zero. I don't know if accounts ever close. They may be called closed accounts, but doesn't mean that they go away.
And what is a closed account? It's an account defined by blacks that neither additions nor deletions can be made, but yet remains open for set-off.
And adjustments.
So a closed account isn't exactly what you might think it is. Again, language of law requires that you really consider all of the words that he uses. Go look up tender, look up set-off, notice of tender. What is a notice? What is a security interest? Try to get a handle on these words. Get a good handle on settle, because you get set off, settlement, and closure. Understand those 3 words. These are the things you're doing, and it's important you have a good grasp of what you're doing.
Now that complete record, because that complete record includes my entire first step, right? It's everything I've done up until that point is that record, including all the certificates of non-response and everything, right? That's the equivalent of a judicial determination. So I've now got a private judicial determination of an account balance set to 0 and a tender for set-off being accepted for the set-off of that account.
Judicial, you mean there was a judge?
Yeah.
Who was the judge?
The notary.
Ah, okay. So an officer of the Secretary of State's office, or technically the Secretary of State himself.
Mm-hmm.
Oh, interesting.
That first process that you're talking about, settle account, that is the same process you'd use for credit cards too, correct?
This process for setting off a credit card, you could do this.
You could do that.
Now, what would you list as the collateral? Because you must list the collateral on the statement or the request regarding a statement of account. What would you list as the collateral?
Account number?
No, that's one of the other elements that must be there. The account number must be on the request regarding a statement of account, but there must clearly be collateral. Jack, what do you think the collateral might be?
The collateral on what?
The collateral, if we were to do this process, or just a request regarding a statement of account on a credit card debt.
What's the collateral?
Mm.
All of the stuff purchased with the credit card?
Well, the alternative is they may come back with garnishment and everything else, so it could well turn into a judicial case in which they're going to do some kind of a hearing asking for where all of your accounts, collateral, and everything are of the public trust.
Ah. So what is the collateral? The public trust.
Straw man.
The straw man. So I would actually put as the collateral the name, all capital letters, with the 9-digit account number with dashes in it.
The social number.
The social security number. Because the debtor is also identified on the request regarding a statement of account, which is the straw man, name, all capital letters. So I've identified the debtor. Now I'm going to identify the collateral, which is the public account, Brandon A. Adams, 123-45-6789. Oh my gosh, I just gave out my social security number.
Did you?
Okay? So, that's, you have a question?
In your initial
Microphone.
In your original presentment to the IRS, and you enclose several credit card accounts, i.e. and or mortgages, loans, so forth, in your original presentment, and then you get your certificate of
I wouldn't do that.
So you do a single presentment.
I would do a separate one. If I'm settling several different, if I'm using this method, each presentment to the IRS Technical Support Division would be separate. Otherwise, I'm going to have to send each bank all of my, right? Because we have to send them a record of what was sent to IRS. I can't send an incomplete record. Redacted? What, just black lines all the way down the page?
Except for the one thing.
No. I do not send redacted records in that because it's a private process. Okay?
And when you send copies, you stamp copy all of them?
It depends. Depends who I'm sending it to. When I send things to judges' chambers, I have my own certified copy stamp. So anything that's not an original that I'm sending to the judge, I flip it over, and on the back I put my certified copy stamp, and I have a seal that I put on there.
Back in front or just back?
Just the back. Okay. So, we've now got record of a settled account. So what's step 2? Step 2, perfect the title. So now that I've got an account, and again, we're not going to just walk away at this point and go, oh, okay, everything's fine and dandy, right? Especially if we're dealing with the place I live in, right? I don't want there to be any kind of foreclosure processes starting. So now I'm going to send them a notice. And I'm going to, maybe I might call it a demand for performance. And the structure, the substance within this demand for performance is going to basically state that, okay, there's a zero balance on this account. It's now your duty to reconvey, well, hold on. If there is already a default, they have two duties. Rescind the default, which means they're going to tell the trustee to issue a notice of rescission, which gets recorded in the public records. Okay? That rescinds the default. And if there's already been a trustee sale, it rescinds the trustee sale and the default. Then I'm going to demand that they reconvey or do a full reconveyance of the deed because the account's been settled. That's their duty. Under our contract, once I've settled the account, it's their duty to reconvey the deed. Right? So, and then part of that, the substance of this notice will also state that if you fail in your duties, you are granting and conveying a specific power of attorney for me to execute these on your behalf.
Why did you put that in there?
Well, just in case they don't perform. Remember, this is a volatile situation in that if it is not handled timely, we could lose the property.
So by you putting in the specific POA or power of attorney, you got an agreement to do that because you brought that up. So
exactly.
You're in a contract mode here, aren't you?
Right. And I'm probably going to do a 3-step process with this, meaning notice of fault, opportunity to cure, notice of default. Because I want to have, again, if I'm going to be executing something under the name Bank of America or any other bank, I want to make sure I've got a complete due process behind them granting to me a specific power of attorney so that they can't come back later and say, that's fraud. You can't execute documents on behalf of Bank of America. Oh, yeah, actually I can. Bank of America granted and conveyed to me a specific power of attorney.
Creditors in Commerce workshop sessions, hereinafter sessions, are the private exchange of ideas and concepts between the providers and the recipients. The content is not meant as legal advice. The use or attempted use of any idea or procedure discussed in these sessions, as applied to the recipient's own personal transactions, cases, or controversies, or applied to other cases, may or may not result in a favorable outcome or the same outcome as discussed in these sessions. Each transition or transaction, case, or controversy may be different as a result of unique actions or unique statements made by the parties therein, and each different act or statement in any transaction affects or may affect whether any procedure or idea discussed in these sessions is relevant to the recipient's transactions or that the outcome thereof will be depicted as in these sessions. The discussion of ideas or procedures in these sessions is not exhaustive of the subjects being discussed. Many ideas and concepts that can affect the outcome of any legal or commercial procedure are not discussed in these sessions, and the fact that the recipients may not be aware of these issues may have an adverse effect on the outcome of the recipient's procedures. It is the responsibility of the recipients to understand their own transactions and to apply the appropriate and complete concepts necessary for a procedural and substantive remedy thereto. These sessions may be redistributed privately by any recipient to another recipient requesting them, condition upon the fact that this notice is provided therewith. If you have any questions, you may contact Creditors in Commerce by email at harmony@creditorsincommerce.com.
Just starting. He's got a question.
We're not taking questions. We're doing trials. We'll be doing the questioning.
I have a statement.
Oh, perfect. Debtor.
We haven't taught them a darn thing, have we?
Evidently not.
Jeez.
Evidently not. Yeah.
I think we're looking at the first defendant tonight. He's going to the electric chair.
You know, we're going to talk a little bit about, we're going to do some mock trial this evening. Again, let's get back to some fundamentals about that. You're going to be entering courtrooms sometime, these public courtrooms. How do you get stuck getting in there? Well, sometimes you may not be able to avoid it. Doesn't mean you got to go in the bar, but it means you might have to go there to defend the public trust, unless you don't care about it. Are they going to send an arrest warrant out for the public trust? You bet. Does that mean they can pick you up? That depends if you're the public trust or not. Might be a little difficult to run around with that. People with censor pictures out there identifying the body, having to deal with it regularly. So remember, again, in all this life, we contend very strongly it's merely contracting. It's said thus: almost the whole procedure of human life implies, or rather is, the continual fulfillment of contracts. You being here, us showing back up, your relationships with your family, spouses, sons, daughters to mothers, vice versa, etc. This whole life is nothing but contracts, and you must start internalizing how to commence and become a creditor in what you do. Debtors do make statements, and we joke about it, and it's cute, but the reality is you need to really consider some serious practice with your friends. And a lot of people are not very good at it because they don't practice at it. Some of you I'm hearing are meeting each other. I strongly encourage you, as my cohorts do, please get together, trade phone numbers. You're all in this area. There's some notaries here. Some of you need notaries. Some of you need notaries somewhere else. You can always contact myself. We have Deborah in the back. She's a notary out of California. She can do your notary work. She gets paid for it like anybody else gets paid for their services, but at least you have a notary there with Deborah. She'll leave you a card if you want. You can contact me. You can contact each other. You should start getting together. We're going to do some mock trials, but let's get back to understanding this whole game of offer and acceptance. Everything that goes on in your life is going to be an offer. When the judge puts out an arrest warrant, it's merely an offer. When the judge makes a judicial determination, or as Jack and I are working with a particular gal out of Canada, she was given notice to vacate by the sheriff with a court order. She's still in her house, and this was weeks ago. Everything's an offer, and that's very difficult for the lay person to get their mind wrapped around this. But if you can, then again, you're merely going to need a good repertoire of conditional acceptances. And you've got to get your mind around the critical importance of understanding, internalizing that definition. A statement by the offeree which has the legal effect of rejecting the offer. Now, Brandon or Jack could make, a conditional acceptance stick that isn't relevant to the situation even. But it's going to be a lot smoother if your conditional acceptances relate with the subject matter at hand. So let us get started with a little court, and let's see how this is all about offer and acceptance.
What we're going to do is we bring you up and you play this game. This is not to ridicule or put anybody down. This is a teaching environment, and that's what we're going to do with it. So if somebody comes in and they're not very good at it, that's what we expect from the beginning. We started out, we weren't very good at it, but what we will do is if they make some mistakes or do it a little bit wrong, then we'll analyze after the person comes up and does what they do, and we'll give you some more ideas. Was this good? Was this bad? How should that have been done? As we go along this evening, what you're liable to see then is we're going to start out to begin with a little bit slow. People are going to make mistakes. That's not a problem. That'll give us an opportunity to point out the mistakes they're making so that when you come up next after that, then you're going to have the opportunity to come in at a little bit higher level. And as we progress, I think everybody in the group ought to learn a little bit more of doing this. Again, I don't know about Gordon. I've heard he's very mean. But I mean, other than that, it's not going to be about trying to trap you up. We don't want to make you cry. We want to get to the point where you understand how this comes back and how it relates.
All right, let's get started because the night is waning.
Okay, so as long as you're behind the lead edge of the two front tables, you're not in the bar yet, if that's part of what you're going to do when you come up here. And so you saw us role play last night. You saw Brandon. You saw me. Chicken shit didn't go up at all last night, did you?
Don't you talk about him that way.
Okay. Good job. Notice how he just deferred onto the other debtor.
You talk about my good friend that way.
Get a room.
All right. So, what position are you here this evening? You're going to be out there too, right? We'll be calling on you. Don't worry about it.
You could be a bailiff right now and really, just...
Yeah, I do need I need some people and a bailiff and a few things. I do need a bailiff and a few things. Let me do this. Julio, you know how to play bailiff. Come on up here. I need a bailiff and a couple. I need a couple of bailiffs, guys. Come on up here. You're my bailiffs. Come on up here. We're going to have a few bailiffs.
He's going to get mean, guys.
Let me tell you something.
He's got an army up there. Don't let him sit on you.
Come on, we got to get some bailiffs up here. I need a clerk. I need a clerk up here. Come on up here, clerk. Believe it or not, if you will get some friends and you will set up, as silly as this looks, like Jack will tell you, a good student of his, 20 years. We set it up in the Elgin deal, Ginger will tell you, and this guy just flat out choked. 20 years working with Jack, going to his Monday nights. He's a neat guy. And it was really good. He took it good-naturedly. But he understood, because unless you practice this, I'm telling you, you're going to choke.
You don't have to be together. Just call your friend up and say, okay, I'm going to be from the IRS, and I'm calling you today. Let's role play.
Come on over here.
It's the easiest way to do it.
These Creditors in Commerce workshop sessions, hereinafter sessions, are the private exchange of ideas and concepts between the providers and the recipients. The content is not
bailiff right now, and really, just
I need some people. Mrs. Romano, are you here with your attorney? This is a simple yes or no. And if you don't answer my question, I'll have the bailiff arrest you. Julio, are you going to answer my question, Mrs. Romano, or not? Yes or no? It's real simple.
I'm here as Ginger Romano, the Paramount Security Interest holder, here to settle, and close any and all claims.
And how do you propose to do that, Mrs. Romano? Did you bring your attorney with you? First of all, come in here where I can hear you. Come in here where I can hear you. Just come in the bar where I can hear you.
Enter the bar while I'm...
Enter the bar now. Enter the bar now, Mrs. Romano.
May I enter the bar while I'm reserving my rights?
Yes, you can. All your constitutional rights are reserved. Get in here.
No, all of my unalienable rights.
No? You're telling me no? You're telling the judge no?
May I enter the bar? Forgive me, Judge. May I?
Are you coming in or out? You keep stepping in, you keep stepping out, Mrs. Romano. I don't get it.
May I enter the bar, reserving all of my unalienable rights?
Maybe you can't. You want to step up to the thing. He said, I'm here today as the Paramount Security Interest holder in all property and collateral, both registered and unregistered, belonging to Ginger Romano.
Your Honor.
Who are you?
Amicus Curiae. I'm here today because there's a Paramount Security Interest in the collateral.
I don't know who this party is. I would find out if he's a licensed attorney.
Are you a licensed bar attorney, sir?
Would I need to be an attorney
If you're
I'm here as a
representing
friend of
anyone
the
in
court.
here, sir, you need to be an attorney. Your Honor, explain that to him.
Why don't you have a seat, sir, and we'll deal with you in a minute. You're a friend of the court. Have a seat. I'm going to deal with Mrs. Romano. Thank you.
Your
Sit
Honor,
down, please.
Your Honor.
Sit down, please.
I conditionally accept upon condition that the record that has been submitted on the private side in chambers, which was
Julio.
submitted by myself, Your Honor.
Julio, I've asked this man to sit down. If he keeps talking,
Your
escort him out of the
Honor,
room.
would you have that man arrested? I have reason to believe he's trying to practice law without a license. He's representing a client, and he's not an attorney, and he's disrupting this court.
Are you the defendant, sir? If you're not the defendant, please sit down.
Your Honor.
If you're not the defendant, sit down. This is my courtroom, and I will conduct it the way I want. Do you understand me?
Your Honor, I conditionally accept your offer to have a seat in the gallery upon the condition that, or upon proof of claim that, as a friend of the court here today to assist you with the settlement of this matter, it would not be in the public's best
Your Honor,
interest.
we don't even know what this matter is yet. The defendant has not even come into the bar. It's obvious that this person standing out there has no legal standing in this case whatsoever. If he's an attorney, I would present the fact that maybe we ought to take him for disbarment on his activity. If he's not an attorney, he has no right to be speaking here unless it's for himself, which is going to be a criminal charge if he isn't quiet.
I suggest you sit down, sir, till we're ready to hear you, all right?
Your Honor.
Would you mind
Your
sitting?
Honor, I would order that man to sit down or be in contempt.
If you're not the defendant, I'm ordering you to sit down or be in contempt, and Julio and his squad will take you away.
Your Honor, I conditionally accept
And they have
upon the
automatic
condition
weapons.
that you take notice
Take them by the legs.
that
Take them by
if
the-
any physical, unconsented to physical contact by any of your officers,
You do not authorize to disrupt my courtroom, so if you'll just hush for a minute,
Sir, just please
you'll
have
have
a
your
seat.
chance to talk.
Please have a seat.
Please have a seat till I finish with Mrs. Romano.
Your
Sir,
Honor.
Step right this way, please.
I think on one side you're going to have to figure out how to come in because you ain't coming in that way. I'm going to tell you right now in a judge's courtroom. That ain't going to fly, dude. You're going down.
we'll see.
Okay, have a seat, Mrs.
Good
Romano.
try,
We're
though.
going to finish.
We're back to the defendant.
What would happen if he had done that, really?
Well, the judge might say, because he's looking at Mrs. Romano, she stood up. It might be different if he'd have stood up and said, I'm here today, and spoke instead of her. But I don't know that once I'm talking to her, he's going to stand in and interrupt me talking to her. I don't think that's going to fly with the judge.
Yeah, but she hasn't identified herself as the defendant yet.
I'll get around
That
to
is
that.
correct. She hasn't done that. But understand this is also a criminal court case. Not that he couldn't come in, but we are going to protect the system. Like, what do you mean you're a friend of the court? The court prosecutes through the public prosecutor. Are you here to help with the prosecution?
Absolutely.
If you're here not to help with the prosecution, you must be representing a defendant. Do you have a license as an attorney, or you have no standing to represent a defendant in a criminal case? That would be our position.
Right.
Okay?
I'm not here in a representative capacity.
Let's move a couple of these, and we'll get around to you, sir. I'll count on that. All right.
State of Jack Smith.
Mrs. Romano. Mrs. Romano, are you in the courtroom today? Why are you standing up in my courtroom, young lady? Are you Mrs. Romano, yes or no? If you're not, please leave, and if you are, get over here and sit down.
I'm here
Which
as
is it?
the paramount security interest holder, and I can't remember all the
That's
rest.
fine. You're here and all that good stuff. And?
What do you want?
And I'm here for the defendant.
You can be here for the defendant. Come on in on those terms and conditions. Come on in. You're all right now. You made it. Now, haul this defendant away.
Your Honor, amicus curiae.
Sit back down. I'm tired of hearing from you. I got my defendant. I got my...
This woman is completely unaware that she is not the defendant. I know the defendant. This woman is going to injure herself, is clearly incompetent. Miss, please step back here.
Your Honor. I detect that this man may have some serious misgivings.
Just hang
here.
on. We'll get you a mental competency test in no time.
This man here has got some typical patriot whacked out thinking.
You know
I'd love to hear the rest of his suggestion, but I just know we need to give this man a
what
test.
she just did is a thing a lot of my students have done. They get a little caught up. No, they get a lot nervous. And that's perfectly normal. They get a lot nervous. I even say you can read from the cue cards, and they can't. It's the most unique thing. But if you got your cue card, read it and not worry about it. You introduced, and you said something, and I said, no problem, it's done. Come on in. But you don't know what I agreed to or what you agreed to. You made a thing you thinking, and because you don't really know what it is, you're real trouble now. Now I got you in the bar, and you're dead meat now.
Okay, let's do a timeout for a second because this is training, right? You did very, very well to begin with because you knew you just couldn't come into the bar, right? And you're struggling for what it is that you're going to try to put on the record, and it's not easy because remember, like we've been saying, she can't exactly say the truth because if she says the truth, we're going to shut her up. So she's got to be colorable. And she had some of the words down almost in the right order. She admitted at the end, and I don't remember the rest. Fine, we can forgive you. But remember, it takes 2 witnesses to everything. So the first time you tried to set your record, then the judge comes back and says, just come in here. Every time the judge opens his mouth, who is the judge talking to? The public trust. Is that who you're coming in today? Remember, our hero that's trying to run to your rescue says she doesn't know who she is. She's going to hurt herself. What is he saying? You came in here and the court sees you as the defendant. That's not who you should be coming in as. You see what Brandon was trying to do? And in a heartbeat, we know what Brandon's trying to do. He's trying to protect her, which we all as a brother have a duty to protect our brother or sister if they're getting into trouble. You just want to go into court and you want to stop everyone from going in that bar. But you see, the issue is the party that's up there has to know their remedy. Okay, so when the judge said to you, okay, fine, rights, just get in here. Who's he talking to? Just get in here. The defendant. So you came in. That's when you became the defendant. What should you have done? He said, just get in here. What are you going to do?
I should have asked.
Should have said, let the record show.
You could have done, let the record show I'm coming in under my protection or my contract. Or you could have said, would it be okay if I came in there under my record? See, if there's 2 people, one the fiction, one the reality, which is the creditor, when the judge speaks, he's speaking to and you're standing right next, he's speaking to the space next to you. And so what do you have to do? You have to get it twice on the record. Would it be okay if I came in here? Well, the judge said, well, I just said, come on in here. But you were speaking to the one you saw, which was the debtor that ain't here. I've got to point out I'm a different entity. Would it be okay if I came in here? Just being that extra statement, plus if you follow his command, get in here. You just granted jurisdiction to the court. Take that toothpick out of your mouth. Up, you're mine now because you followed my order. So if you come back and mirror him his command, get in here. Your question, would it be okay if I come in here? One who questions is one who is a creditor. And so if the judge would have said, okay, he now answered you, you're in control, you come in as the second party who's the creditor. You see the games we're playing?
Let's roll another one. Let's go.
Okay? You're
Have a
excused,
seat.
ma'am. We'll hold you in hearing again next
Jack
week.
Smith versus Justin.
Did a good job.
All right, let's go. We got next case. We got a lot of cases to get out tonight, so we're not going to be messing around with too much of this. So, prosecutor, I appreciate that.
State of Jack Smith versus Justin.
Oh, Justin. Oh, my. Your Honor, Justin was caught. He's promoting dog fighting. And that's a felony in this town. Those poor little dogs. When they got there, I don't even want to describe the sight. It's a felony. It's only in the 4th degree, but this is serious, Your Honor.
All righty, I understand that.
Your Honor, I'm here as the authorized representative for the defense.
You an attorney?
No, I'm a paramount security interest holder in the defense.
In the defense?
For the defense.
What do you mean the defense?
For the defendant.
What do you mean for the defendant?
I'm here as an authorized representative for Justin McPherson, here after known as the defendant.
And you're authorized for what?
I'm a paramount.
Your Honor, if he isn't the defendant, we better find that out because we may have to put out a warrant for failure to appear.
Sir, I'm going to warn you, if you're not the defendant or you're not counsel for the defendant, are you a licensed attorney?
Your Honor, I'm here as an
It's a simple
authorized
question,
representative
sir.
for...
You're either the licensed
Let the
attorney
record show
or you're
that
the
I'm here
defendant.
as an authorized
Are you going to keep
representative.
arguing and talking when I'm talking in my courtroom? Am I going to have my bailiff take you out of here? Do you understand when I'm talking, you're quiet? Is that clear?
Let the record show that I'm here as an authorized representative for the defense.
Great, okay, then come on in. Since you're the authorized representative for the defense, come in here and defend. Let's go.
Does anybody here, Judge, you or anybody else in the courtroom, have an original charging instrument for my inspection?
Matter of fact, I do, right here.
Your Honor, I would certainly determine whether this gentleman is the defendant.
Clerk, would you give him a certified copy of the charge, please?
Your Honor, before you do that, are you going to just give anybody a copy of this charging instrument, or are we going to determine whether or not he's the defendant?
If he says he's here to take care of it, not a problem. Now, are you going to get in the court here? Because I appreciate that
Bailiff, could you please return this to the judge?
Has this got any relevance or meaning to you?
Your Honor, it's obvious that this defendant has defaced government property,
It's just a
which
copy.
is another...
It's just a copy.
Oh, it's a copy. Well,
Yeah,
he's
didn't hurt
still written
Your Honor,
on
is
this
that not a
document.
certified
Your
copy
Honor,
of the
we
original
still
charging
don't even
instrument
know if
as you
this gentleman is the
stated
defendant.
earlier?
Excuse me. Is he not talking? And when he's talking, you don't need to interrupt. Do you understand? It's real simple.
Your Honor, is that not
Do you
an original
understand me?
certified
Do you
copy?
understand me? Do you understand what I
Let the
said when
record
he's
show
talking?
that
Your
that
Honor,
is
This guy's
original
going to get
charging
his butt
instrument.
arrested. That's
Your
what's going to
Honor,
happen.
I would probably have the bailiff escort this gentleman back.
Bailiff,
and
why don't you go stand
sit
next
him
to
down.
him? If he's one more
Let
time
him-
like that, you will be held in contempt. Do you understand
Let him
me?
think about what he's doing,
If
and
you
we'll
interrupt-
call him back in 15 minutes.
You interrupt me one more time or you interrupt when someone else is talking in this courtroom, you will be arrested. Do you understand that? That will be a contempt of court.
Let the
It's
record
a simple
show-
yes or no.
Let
You're
the
now
record
running the
show-
red line. I will tell you this. He's now going to have himself in a lot of hot water. Because, see, he's interrupting here when his guy's talking. He's got to talk. Remember we said, relax, you're going to get your chance. Remember? So chill out. All right? So, now, you had a question, sir, regarding this certified copy that you have written all over. And I might tell you that if the prosecutor wants to charge you for defacing a government instrument, that may be exactly what
We'll
he's
have
gonna
to
do.
add another charge here, Your Honor, to this particular defendant.
Now, you've been charged with 2 counts of promoting dogfights. Do you understand that?
Poor little lassie.
And let me tell you something, Mr. Justin. Are you listening to me? Dogfighting in this state's a very, very serious offense. Animal cruelty is considered a heinous crime around here. And it's a particularly difficult one. Matter of fact, I have one of my clerk personnel right here is a veterinarian. And she can tell you it's not good for you. There's probably something wrong with anybody that promotes that kind of cruelty. Now, I'm not one to judge that. But in this matter, you have been charged. You were arrested last week. You got booked. You were released on your own recognizance. And you've got a very serious matter to deal with here. This is an arraignment. This is merely for you to either plead guilty or not guilty. So, what's it going to be, guilty or not guilty?
Your Honor,
Bailiff,
I contingently
have
accept,
that
Your Honor,
man
a proof of
escorted out
claim
the
that this
courtroom.
matter has not been
Excuse me,
set off.
Excuse me one moment, sir. Have that man escorted out of the courtroom. When you slip notes to people, the judge, well, that's the same as talking in his courtroom. And it's real strange because you can't even just pass one like that. It's okay if he does, but that man is out of my courtroom. Now, you have something to say, Mr. Defendant?
Actually, as long as it's practice, let's back up.
You know what? I can't even hear you. So why don't you come in here where you can be heard? It's a real simple request, sir. If you want to be heard, if you want to be heard, you come in here. If you don't want to be heard, you just stay out there. I need to talk to the defendant. You don't want to come in here. You don't want to talk. That's just fine with me, because I'll just simply have you escorted out of here because you're interrupting court proceedings here. This is my courtroom. Do you understand that? I'm asking you a question.
Let the record
If you
show that
answer
neither the
something
judge
else,
nor the prosecution
take him out
has
of
a
here. He's
problem
not
with
going to talk over me like this. I told you not to talk over the judge. What's wrong with you? Now, what are you going to do with this certified copy? You signed the certified copy, and then you go, is this not a certified copy? Yeah, it's a certified copy. And what good's this certified copy? Copy, it's not the original. You better find out it's got an original signature on it. So it gets kind of cool, but you're doing good. You're not bad. You know, he's doing real good in that he's not going to give in. He's going to say what he wants to say. Where he could do better is that he doesn't want to be over-talking the judge and interrupting the prosecutor and that kind of stuff, because he wants to say what he wants to say. He's been told not to interrupt, but look at him. He's sitting there interrupting. I'm saying, hush up, and he keeps talking. He's just going to get it out if he's got to go to jail to get it out. It's not going to help him. But you did pretty good in. Look at the good points he did. He's not coming in the bar. He's going to say what he wants to say. He's going to say what he wants to say, and that's all there is to it. And that's what you have to be, is tenacious like this. You have to not give in, although you got to decide what you're not going to give in on. But you did good in that you did not give in. I'm wanting you in here, and you're going to say what you know. No, I don't. Just get in here. No, he's going to want to say what he wants to say. So we better get the.
Before we go on, let me make a statement. If everybody is doing as well as the first two people here tonight, understand this. Are you going to expect to win? Yes? How are you going to expect to win in this arraignment or appearance? Do what? Not enter the bar, okay, but that isn't going to finalize the case. Agree with that. Okay, well, you might try that. Do you think the judge and the prosecutor is going to rule in your favor? No, what we say is going to have to go against you. Did you see what happened to Dwight last night? It's got to go against you because of what? What is the primary duty of the judge and the prosecutor? Protect the public, which is the court system. All we are is a debt collection corporation. We want to get paid on the piece of paper that is a debt account. Even if you do 5 stars out of 4, we're going to rule against you or shame you to get you out of here. We've got to do it.
Let's roll it forward, and let's call State of Jack Smith versus Brandon Adams. a particularly heinous crime, I might add, the prosecutor do this. Because what we're going to do is we'll do a few of you, and then let's see how Brandon does again. And this will give you a chance to pick it up. Watch what he does. State of Arizona versus State of Jack Smith versus Brandon Adams.
State of Jack Smith versus Brandon Adams.
Thank you, Your Honor.
Amicus curiae, Your Honor.
Excuse me, sir.
I'm actually here to.
Thank you, Your
I'm just
Honor.
here to assist you with the
We gotta
settlement.
deal
You will be
with this.
sitting in the
Excuse me.
gallery.
If you don't mind,
representing
my
third-party interests.
prosecutor will be speaking first. This is the order of this court.
This
we
is-
have orders that we generally. Can you just wait a minute while he speaks? Would that be all right? Please.
Your Honor, would it be all right if I stood here in front of the bar while you address the prosecutor? When you're done with the prosecutor, may I address this court?
I think that's the intent, is it not?
Are we in disagreement?
Does it sound like it?
Let the record show that there's no disagreement.
Not yet.
Mr. Prosecutor?
Your Honor, this outburst was typical of this charge. This gentleman is charged with contempt of court. He has disrupted this court on numerous occasions by coming in here with this fly-by-night attitude that he's here as the friend of the court. You have warned him once, you've warned him twice. Again tonight, you've had to tell him to wait his turn. Contempt of court, Your Honor.
Is the defendant Brandon Adams in my courtroom?
Your Honor, amicus curiae.
If I wanted a friend of the court, I'll call my friend, all right? If you're the friend of this court, you will sit down and be quiet till I find out whether the defendant Brandon Adams is here. And if you're the friend of this court, you'll sit down. If you're not a friend of this court, then you must be the defendant. And if you're not the defendant, you don't belong talking, or unless you're the counsel for the defendant. Are you one of those?
Your Honor, I'm here as a
It's a
friend
yes
of the
or
court.
no question, Mr.
Adams,
name?
sir.
Your Honor, I'm
What
here
is
as a
your
friend
name?
of the
Who
court
are you?
to assist you with the settlement of this matter. When you need my assistance, I will be seated here. I represent third-party interests in this matter. So you may continue with the proceedings.
You represent third-party interests?
Yes, I represent third-party interests in this matter as a friend of the court.
Your Honor, this man is here under a criminal contempt charge. This is just more idiotic, patriotic complaining again. He's toying with this court, Your Honor.
Is Mr. Adams in the courtroom as counsel for Mr. Adams? If nobody is, it's one of those two things, and if not, let's go on to the next case.
Your Honor, I think we ought to put out an arrest warrant for Mr. Adams.
Your Honor.
Clerk, would you kindly, excuse me, I'm talking to staff. Would you please put out an arrest warrant for Mr. Brandon Adams? Heinous disregard for a court order to show up. Classic display of recalcitrance.
Is that a crime?
I've heard that he hasn't been showing up often. So at this point in time...
Your Honor, I would add a clause to that. I think he's dangerous. He's one of these patriots, and he is a paper terrorist.
And a terrorist. So, call the next case, please, and that
Your Honor,
would be...
Your Honor, I conditionally accept you.
Excuse me, don't
calling
interrupt
the
my
next
court,
case.
sir. Are you the defendant?
Your Honor, I'm here in regards to this matter.
What matter?
This matter
I'm
of
on the
State
matter of
versus Brandon Adams.
I'm on the matter of State Smith versus David. Are you here on that matter?
Amicus curiae, Your Honor. David who?
You're going to have a problem. How about do for me? Instead of amicus curiae, let's start again. Why don't you come in as what one of these people come in, or rather, so they can get used to how to deal with this on their own, okay? Amicus curiae, or friend of court. All righty. State of
Jack Smith versus
Brandon Adams.
Your Honor, we're here today. Brandon Adams is charged with contempt of court. He's been here numerous times in the last month. He always comes in as this friend of the court. We are a criminal facility, Your Honor. We're just looking to resolve the issues with the defendant. He is interfering, harassing the court, and causing all kinds of confusion. He's here on contempt.
And it looks like also promoting dogfighting?
That was the last case, Your Honor.
Well, it looks like he's accused of it too. I got two of them here.
I wouldn't doubt it.
Mr. Adams, how do you plead?
Good afternoon, Your Honor. How are you today?
I'm fine. How are you?
I'm very well. Thank you for asking.
Are you the defendant?
Your Honor, I'm here today in a capacity of a secured party interest holder, or the secured party paramount security interest holder. I have, if you've received in chambers the evidence that has been submitted under seal, I am the party representing those interests in this matter. As the record shows that has been submitted under evidence, there is clearly a settlement in this matter and no disagreement of the parties. I am merely here to ensure that no security interests are prejudiced in regards to this matter. And if it please the court, I will have a seat here while the proceedings persist. I'm just here to make sure that none of the interests are prejudiced. Would it be okay if the court if I sat here?
I tell you what, why don't you have a seat until I conclude some business, and then we're coming back to the plea deal from Mr. Adams, all right? That fine
Would it
with
be
you?
all right if I sat right here, Your Honor, in the gallery?
Please do. State of Jack Smith versus...
Okay, before we go on, how did Brandon do this time? Okay, everybody was courteous enough. Everybody listened to everybody else. Obviously, right now, the judge doesn't want everybody out in the chambers figuring out what's going to happen next here. If the judge would have come to the prosecutor to say, what do you think, what would the prosecutor have done? Okay, what did Brandon say? What was his business? What was his defense? He never admitted being the defendant. He never came in the bar. What did he say was there? There was a record of evidence where? Judge's chambers. Would I see that? No. However, in obtaining that record, he said there was a settlement. Who would have been involved in the settlement? What? He would have had to come to me to get the settlement. So if he said, I brought a record of settlement, would I know what that record was? I hadn't seen the record, but I know that the settlement had to be with me. To bring a settlement to me, we have to exchange papers or do something? So I would be aware of what Defendant Brandon was doing. But if the judge then decided to continue with the business right then, instead of setting down so the rest of you aren't going to listen to this, you'll be long gone. So the judge did a good thing. But let's say the judge came to the prosecutor and said, well, what's he talking about? What do you think? And played dumb on the record that's in the court. How would I have responded? I got all this wacky paper.
Gibberish.
Man, it's insane stuff and it means nothing.
Gibberish.
Gibberish, typical patriot crap. He's once again trying to just lead this court on, and then it would go back to the judge. Now, in the judge's mind, what's going on? You don't think for a moment he read that record? He had to have read that record, or he's not doing due diligence in his job. So he knows the record that Defendant Brandon came in with on the private side. He knows that if the record is perfected, he's got to protect Brandon's interest. He knows that what I'm saying because we've got to protect the public facade from somebody that knows his rights and is doing it correctly. And so at that time, the judge may have said, okay, sit down and we'll get to it later. Now, when he said to Defendant Brandon, sit down, had Brandon walked over and sat down, the judge is speaking to the debtor, even though Brandon has not yet called himself a debtor. And if he follows the judge's order, then he must have appeared, and if he appeared, he must have been the debtor defendant, and therefore when Brandon sat down, oops, What happened to Brandon's record in chambers? Vanished. Next time he gets up, we're going to have the bailiff drag him in here and arraign him.
They have literally drugged people into the bar. That's fact.
Because he is now a debtor on the record.
Why is he a debtor on the record?
Because he followed a judge's order. Go sit down. We'll get to you later. If he
I ordered the defendant or this person, go sit down over there, and he goes, would it be all right if I sat down? I did one in my first hearing because I was a little unsure, and the judge says, I'm going to reset this hearing for out like a couple of weeks. And I'm giving you an order, Mr. Hall, to be here. And I said to the judge, would it be all right if I came to the hearing July 15th at 10 a.m.? And he goes, I have other business to hear now. I said, have a nice day.
He set the record. You set the record.
So in other words, what Brandon just did was not follow my order. There's an old story about a guy coming into court holding up his mud good. On the way out, he's got a toothpick in his mouth, and the judge says, oh, by the way, take that toothpick out of your mouth. Took it out.
Turned around to look at the judge.
Which
the judge ordered the bailiff arrest that man.
Was that you in the courtroom, Julio, with the earpiece? No. I had one of, I forgot which client it was. He went into the courtroom with his Bluetooth on. Might have been off, and the judge said, take that thing out of your ear. Not good. Yes, Scott.
If he would have defined himself as a defendant, the paramount security interest holder, as a defendant, then if you said sit down, could he sit down?
Well, let's do one, Brandon. Let's do a quick one with Brandon. Why don't you do me a favor? Come in and the authorized representative for the defendant. We're going to charge him with, much like, we're just going to charge him not with any of that stuff. We're going to charge him with dog fighting. He's just going to come in, one of you patriot types, with he's going to be the authorized representative here, and he's one that gets his hands on the he just got arrested last night, so he hasn't had a dime
Straight
to do
from
it
jail?
to do any kind of stuff. He hasn't granted jurisdiction with didn't do anything, so he's going to try and get his hands on the charging instrument. Okay,
now watch what Brandon's doing, because he's got a lot of experience. And what he's doing right is very subtle. You may miss it in a heartbeat. Number one, he was very courteous. You're doing business, but you don't have to be mean to honor the other people. Be courteous.
Actually, this is going to be the guy, Brandon, that's been in and out of our courtroom. He messes it up. He comes back with this paperwork and refiles, and etc. So we're going to do you know which one I'm talking about, with the Dwight one.
So I'm no longer trying to get the charging instrument?
You have done your private administrative process. You screwed it up again at the last hearing. And so this is another pretrial status conference hearing.
So is my process in chambers on record?
No, your process is yes and no, it's in chambers. You know, you're Dwight out of Texas.
Kind of like in the public record right now.
It's kind of like in the public record. You didn't realize this private side thing very well, so you don't really have it there.
But it's going to be criminal. Your Honor, this man has been charged with simulating legal process, and he has filed documents in this court right now which is causing a lot of serious problems for public officials.
Has this been going on for a long time?
It has been, Your Honor. These documents are in and out. The clerk tried to keep them out, and he insisted they went in. He got another clerk. He got these documents into the file again. It is creating serious credit repercussions on public officials and other private people. Ruined their credit.
You know what I'm probably going to do is revoke the bond. And I can see you didn't bring an attorney with you again, Mr. Adams. And I'm going to tell you now that if you don't have an attorney with you at the next hearing, which is now set for 30 days is going to be at the next docket hearing. If you don't have an attorney, I'm going to have you arrested. I'm not going to accept any more of your conditional acceptances. I'm not going to accept any more of this silliness that you do. And you may find yourself charged again with some additional simulated legal process. So at this point in time, what I'm going to go ahead and do is I'm just going to reschedule this for 30 days from now. I'll let this guy speak at all. This happened. Do you understand me? You have a hearing to be here in 30 days. I've given you the terms and conditions.
Good afternoon, Your Honor. I'm here representing the Paramount Security Interest Holder today. Would it be all right if I attended that hearing in 30 days?
That'd be just fine.
Thank you, Your Honor.
What should he maybe have done, Mr. Prosecutor Smith?
See, I want that 30 days because now I can get my private process done and then on the private side.
Now, he forgot. I told him that he'd already done his private process. It just wasn't on the judge's chamber, so
Right.
you just got him.
I just got what?
You just got hoodwinked.
No, I
You
didn't.
just got, yeah.
We'll see in 30 days.
Now, what Brandon's saying is what you'd forgotten. We said your process was done, and this was Dwight's. But he's right. Where he didn't have a process in, let's do one where this is just the day before. You just got arrested for dogfighting. We'll bring him in. He's got no simulated process. Let's just charge him with dogfighting.
Before we go there, let's go back to the last one because there were a bunch of orders that came back to the defendant. Bring in an attorney, don't file any more papers, do this, do that. Now, do you understand me? Are you going to be back here in 30 days? See, it was kind of a compound order. It was this and this and this and this and this, and then finally the emphasis was be back here on 30 days. When he said, I will be happy to be back here on 30 days, did he rebut the assumptions that he needed to have an attorney?
Well, if you're talking about me, Dwight, I didn't address it because I did not confess to being the defendant. I said, Your Honor, I'm here today representing some interests. Would it be all right if I came back in 30 days to that hearing? I haven't confessed to being the defendant.
This is contract law. He's right. All of this stuff doesn't matter because he precluded it. I just reset a hearing, and he knows what he's going to do is go do all this administrative remedy. And whatever happened today is going to be gone tomorrow as soon as he starts his process, because that's all that's going to be on my desk, because I'm just going to see the last stuff up. So in that sense, he's correct in that.
So you heard what Brandon said. His contract to the court of who he was not taking on the capacity of the debtor.
So I don't have to have an attorney.
So he has no care. When he comes back, he's protecting his interest and going to set off anything for the debtor.
Oh, and by the way, Your Honor, I'll make sure if the defendant comes, he has an attorney.
What do you need?
What if you would have said, went through the...
Let's get a mic if we can.
Well, I'll tell you what. Why don't you come up and you're on the seat? Bring that mic with you. Let's go.
What happened to my
State of Jack Smith versus Tim Williams. Another dog fighting with a heinous crime.
Man, there's a lot of dog fighting going on here.
State of Jack Smith versus Tim Williams.
Your Honor, this gentleman was also involved in that same dogfighting incident as a promoter. So again, it's a fourth-degree felony.
Is Defendant Williams in the courtroom?
Your Honor, I am the authorized representative for and secure party interest holder for Tim Williams, hereafter known as the defendant.
Okay, then come on in. Let's get started.
I'd like to let the record show that I will enter the bar while retaining my God-given inalienable rights.
I don't think so, so just get in here anyway. Don't be backing up in my courtroom, do you understand? When you step forward in this courtroom, that means you step into the bar. Is that clear?
Thank you very much, Your Honor.
Is that clear?
I'd like thank you very much.
It's a simple question. Is it clear?
I thank you very much, Your Honor, for inviting me.
Kind of interesting. I thank you very much. What? What's he saying? Is that clear? I thank you very much. Is that clear? I thank you very much. Kind of interesting. Works, doesn't it?
I think he likes punishment just like those poor little puppies.
He's doing good. Thank you very much. Go ahead.
Again, Your Honor, if you'd like me to come into the bar, I'm more than likely to come into the bar while retaining my God-given inalienable rights.
Did you bring an attorney with you today, Mr. Williams, for these charges?
Your Honor, I am.
Excuse me, one second, Mr. Williams, before you get started. Do you realize the seriousness of promoting dogfighting? You know, we just had a professional football player recently who's guilty of this same thing. And you're not a professional football player, are you? Like, that could get some leniency. I mean, that football player got some leniency, got a little time. Are you a pro football player?
Well, Your Honor, I definitely accept the story that you've given me of what has happened to previous folks that have been convicted of dogfighting. However, I'd like to examine any claims that have been brought up against me.
Do you happen to have a claim? Come on in. We'd be happy to. There we go.
I think we can accommodate this defendant.
Clerk, would you kindly give Mr. Williams the claim against him? We've got a certified copy right here. Mr. Williams, please step in here and let's get started. You can examine it.
Your Honor, thank you very much, Your Honor. But again, that is a.
Are you refusing the offer?
Your Honor, I conditionally accept the offer, but of it being
bailiff,
the original copy.
Bailiff,
bring the copy back.
Remand this man to custody. Now,
Your Honor,
what are you doing resisting? What are you all going to do if somebody comes up and grabs you? Don't you resist. Don't you pull back. That is a sign to fight. You're toast. And they will literally, and they can, they'll attack you right there, slap cuffs on you.
You think the dogs got beat up.
You say, well, if I can examine he caught it, the claims against me.
Right.
Excuse me, Judge Hall, do you or anyone else here now, today, in this courtroom, have an original charging or accusatory instrument for my inspection?
Yep, that's what he said, Your Honor.
I got a certified copy right here. Why don't you give it to the man?
However, Your Honor, do you have an original copy of a claim that has been brought against the defendant?
Right there.
Your Honor, this appears to be a certified copy and not an original accusation.
What's the difference between original? What's the difference between original and certified?
Your Honor, do you have an original signature copy?
That's got original certified signature on it. Yes, I do. You got it in your hand.
But Your Honor, I'd like to have an original signature, original wet ink signature.
Why? If you can tell me why, I'd be happy to give it to you.
Your Honor, to validate the charge that has been brought forth.
Ah. Could you continue to explain what validate means to me? I don't understand validate.
Verifiable proof, Your Honor.
You keep making statements.
You just explained something.
You know something, prosecutor? I get tired of these people coming in and they think I'm stupid, so they go off explaining stuff to me. You know, that is a contempt of this court. Because how could this guy be so arrogant as to think I don't understand a simple word like validate? You know, I've forgotten more than he'll ever learn. So what do you think we ought to do with this arrogant guy who likes to explain things? You know, what did we do with that doctor the other day who explained to us what UCC 1308 was when I asked him?
Went straight back to prison.
And that's where he went. Back to jail. He was getting out. All he had to do is what I did with Susie. This is another contempt. Been in over a year. All this guy had to do is go in and be nice and be a good little debtor. He didn't understand that. And so when the judge said, well, can you explain what this UCC 1303 reservation of rights means? And when he started explaining, clerk, could you go grab a Black's Fifth for us so we could see? And she went and got it and then came back and gave it to him and he explained nicely. Beautiful. I really appreciate that, Mr. Williams. So, gentlemen, if you please escort him back to his cell till he can learn something better. Big time problems. You can't, remember? Got just 4 doors. I made an offer and he went through which door? Did he go through a straight acceptance, conditional acceptance and honor? No. Did he go silent? No. He argued. He explained something. Remember we said.
So he just made a mistake. I'm the prosecutor, Your Honor. I believe that this gentleman has a certified copy. It explains every charge against him. That's all he needs to get. He's either going to address that issue and then get in here and sit down, or you're going to hold him in contempt. Why am I recommending that?
Because he explained.
Because he explained, which means is he a creditor or a debtor? Does a debtor get an opportunity to examine the original charging instrument and set it off? No. So I'm coming back, and your indication is I'm now requesting that he just review what he's got. It tells him the charges. It's a certified copy. He does not deserve the original. Have him come in here, sit down, or be in contempt. That's what's going to happen. When you make a mistake, you're going to get treated like a debtor, and that's your first, ooh, my bad. Something just happened, and I caused it.
And we talk about 3 special words. I'm sorry, I apologize, forgive me. Something we haven't talked or delved into deeply is this is all about claims. So, when you say I'm sorry, sorry is defined as inferior substandard. This would be a sorry excuse for a bed to get, like just carry my t-shirt and lay here for it. This is a sorry excuse for a bed. It's inferior, it's substandard, it isn't bed quality at all. Apologize is defined as to make a formal defense in speech or writing. So you don't want to be doing that because you defend, you're dead. And forgive is defined as to give up all claim to punish or exact penalty for. So when you make a mistake, don't say, I'm sorry, Your Honor, I apologize, I didn't mean to do that, I was just out of my mind. Yeah, you're sitting there defending. Forgive me. That's not a request, that's a command. I didn't say, please forgive me, I said, forgive me.
But that requires correcting the problem, which is why the term forgive me is the right one. Apologize doesn't require anything. Or I'm sorry doesn't require anything.
Lose those
are
words.
Debtor things because debtors don't have to do anything.
Lose those 2 words out of your vocabulary.
Sorry.
I'm sorry because you're not sorry. Creditors are never sorry. Sorry is like inferior. Is a creditor inferior? You're sons and daughters of God. Are you junk? Are you inferior? Not at all. So you're not sorry.
Everybody in jail is sorry they're in there.
Yeah, I know that. I'm a judge. Of course you're sorry, or you wouldn't have done what you did. You're not asking me for anything unless you say, forgive me. And am I required to forgive, Jack?
Only if you want forgiveness.
And you think I'm stupid enough not to want forgiveness? I know what the law book says. I know what that major commercial code book says. Forgive others is the way you want to be forgiven, and I'm not stupid enough to not understand the law. I'm definitely going to forgive if you ask, but I guess you got to ask or you don't get it, right?
Yep.
You got to knock.
Or seek, or ask.
Yeah.
Please forgive me, Your Honor.
He wouldn't hurt himself with please forgive me, but
What you just said. Do you want to?
I said don't use the word please.
Oh, I thought you said do use that word.
No, it wouldn't hurt him to say
It's
please
polite,
forgive me.
But
It's
forgive me is the call to order. It's a pleading before the court.
Okay.
But now that the judge said, well, what are you trying to do? The forgive me.
How about like Dwight? I'm not in the forgiveness business, Mr. Williams.
There's the judge, yeah. I'm not in the forgiveness business. Where are you going to go with that one?
I'm telling you, it gets...
Forgiveness is for God. God is not in this courtroom. That's the way they act most of the time.
And this judge told Dwight, I'm not in the forgiveness business.
Who would be accountable for that?
Huh?
Thank you, Your Honor.
Right.
Well, so you're going to accept that he doesn't forgive him then?
Well, listen to
is
the
that
words.
acceptance?
Listen to the words. Did he not forgive him?
No, it just is not forgiveness.
He just said, I'm not in the forgiveness business. You guys, be present.
So be more like, well,
be
Your Honor, I
present.
do accept that you're not in the forgiveness business, and
Not in.
I'm not in the forgiveness business. He didn't say he didn't forgive you, so you just keep on moving. For as far as I know, he just
you
forgave
don't
me.
care what he says. He's testing you. You ask forgiveness. The law says if the judge won't forgive you, he's in serious problem. That's his life. But you ask for forgiveness, which means you said, I want to go back to being a creditor. Okay, you just opened the door to creditor again. Enter that door. What's your next response?
Now think about this. He made an offer, forgive me. I got 4 doors. You think I don't understand 4 doors? You think I don't? Oh, I absolutely do.
He can argue with you. He can
in fact,
ignore
the
you.
door the judge went through was acceptance.
Very good. But if he doesn't know that, all he heard is what a layman heard.
Remember, if he argues, who's the debtor? No, the one who's arguing. Who's the debtor? Who won that round? He said, forgive me. His statement was a creditor. The judge argued, which means the judge will admit he's the creditor. It's mere image.
Tricky. Gets tricky, I'm telling you. But you'll get a handle on this.
See, by arguing, he made him the creditor. If he accepts it, he made him the creditor.
But y'all aren't doing bad because you're getting your introductions pretty good, so let's get a new one up. That's right, you did good, Tim. Don't worry, because we're not easy.
I know.
But you're seeing a common. You're seeing a very good common thread with all of you. I got to congratulate you. You're saying you're getting your introduction in there, and you're not kowtowing and falling apart and doing. You're speaking, and that's not easy. You'd be surprised how many people just plain lock up and don't speak. So you're all doing pretty good in the start of this stuff. We better have state of Jack Smith. Let's verse this Brandon Adams again, and let's see if we can do a kind of this guy Brandon Adams is a real simple one. He was just arrested yesterday for you know what? He's that guy that the Forestry Service brought in on drug charges. But he didn't get booked or anything. We've got some charges here, but you know they're not really valid charges. But you know he didn't know it, so let's give it a shot. Again, a short one. It's State of Jack Smith.
State of Jack Smith versus Brandon Adams.
Your Honor, this particular gentleman was caught in the national park system. I think he was toking down or something or other. There's marijuana. There's probably crack. There's probably a million things. Now, unfortunately, these people ditched most of the drugs, but marijuana was definitely seized, Your Honor.
Well, it looks like I got 2 felony counts and a misdemeanor. Is that correct?
I believe so, yes.
Is Mr. Adams in the courtroom?
Good afternoon, Your Honor. I'm here as the paramount security interest holder in this in the property and collateral of Mr. Adams. As such, I'm here to examine the original charging instrument so that I may assist this court with the settlement of this matter.
Kind of interesting. Let me have a sidebar up here with you, prosecutor, for a minute.
Yes, sir.
I think we might have a problem here because he
Sounds
was
a little crazy to me.
Yeah, I wish he was crazy. He was a little on the smooth side. I think he knows what he's talking about here.
He seems to, but you know.
Do you have the original charging or accusatory instrument with you?
Well, you know, we got to have it here, but he probably doesn't know that. Let's try to slip another one in.
Do the certified copy one?
But you know, sir, I'm really upset with this. We don't even know if he's the defendant. He's talking something about property.
You know, I read the deal from the...
We may need to have...
From the sheriff's office.
Smoking a little too much, we may need to have a psych.
Yeah, I wish it was. Yeah. I'll tell you something. Just go with me on this, prosecutor. I know a little more than what's going on than you do, and I'm going to tell you something.
Yes.
This could turn into a problem for you, because I know you're not really familiar with this, but he appears... He may be onto something here, and for reasons I don't need to fully disclose to you, he's... very apt to get at us. So we're going to try and slip him a certified copy. Do you understand?
Gotcha.
Now, if he's onto the thing, what we're going to do is we're going to do a little bit of, I want you to cut him. If he starts to talk, we're going to cut him off. We're going to do a thing, and we're going to, you remember the toothpick one, right?
Can't have him
We'll try and let's see if that'll work. And if it doesn't, I got a couple others to slip him. I've got a good one I used last week. I told a person that was coming
You know
in.
what we ought to do with this? Appoint him an attorney right off the bat. He isn't one.
Let's try the appointment of the attorney.
Do the
I'll
attorney
go ahead and do
thing.
that. All right.
Yes.
Go ahead and sit down. Mr. Adams, I really appreciate you coming here. I'm going to go ahead and get this thing started, and I appreciate your offer to help settle this thing. And I'm going to go ahead and appoint you attorney. Julio, I'm going to go ahead and appoint you attorney. You're here to help some people today. Why don't you go over and see if you can give Mr. Adams a quick hand here, okay? And let's see. Let's put that mic in your hand so we can see. Why don't you Mr. Adams, if you just take a moment to speak. I'm going to go ahead and appoint you a public defender because I don't see that you have one with you. And if you just take a moment to talk to him, I'd appreciate it. So,
Mr. Adams, could you step with me into the little conference room area here? We can just sit down and discuss this.
Your Honor, I conditionally accept appointment of a public defender upon condition that,
Mr. Adams,
upon proof of
really
claim
don't
that...
want to be doing that to this judge.
it's okay, Julio. It's okay, Julio. Let's let Mr. Adams. He's got something to say.
Okay,
Your Honor.
You know, I told you this could be trouble. This guy's
Your
getting
Honor,
good.
I would warn the defendant that he has a right to remain silent. Anything he does say can be used against him, particularly until he talks to his attorney.
Did you understand that, Mr. Adams?
Your Honor, I conditionally accept the appointment of an attorney upon the condition that the attorney accept private payment or private funds for payment, such as to not
Your Honor, I hate
prejudice
to
the
interrupt
public.
this particular gentleman, but he is really sounding more crazy as time goes on, smoking all those joints. And at this particular time, I really think he needs to talk to that attorney, and we may need a little bit of psychiatric examination to see if Mr. Adams is competent to proceed in this matter. Would you instruct the defendant to talk to his attorney, or else I think we ought to hold him for a psychiatric examination?
Do you think perhaps he ought to be remanded to custody for maybe a month or two to see if he likes sitting around in the county jail over here as a guest of ours based on what appears to be, some very heinous violations of court etiquette?
Well, if nothing else, Your Honor, I would give him the opportunity to speak with his attorney, but if he keeps interrupting the court, I would take him into custody for his own good, because he's beginning to sound dangerous to himself and incompetent to handle this matter.
It's people like this that we get in our courtroom that cause this system to get clogged up a lot. Guys like this think they can go out and play with drugs, and like you said, there was a lot of other drugs. It just wasn't that little bit. There was like a dozen of those people out there, and this is not a good thing.
Not a good thing.
Can I come up to the little
Again, Your
sidebar
Honor?
here, prosecutor? Yes. We've got a real problem. This guy knows what he's doing, so we can try this a little more. Maybe we're going to buffalo him, but if not, let's try the... let's just make sure that the Julio stays next to him just in case. And
we can't have him doing this. He's teaching the people too much. Order him either that he's going to be released to go to a psychiatric exam, or else he's going into custody for his own good. We'll sort the rest out later.
Good enough. Mr. Adams, what I'm going to do here is, because I'm concerned about your what appears to be mental incapacity. That means in this courtroom we have rules. It appears that you don't want to accept counsel. You think you can appear in this court without counsel. You think you can do what you want. And I'm going to tell you what. I don't normally do this. What I'm going to do is I'm going to release you on your own recognizance. But I'm going to instruct you that you're to get a mental evaluation. And if you don't get that mental evaluation when you come back in here, and I want you in here, I'll tell you what, what do you...
About 2 weeks, Your Honor. I have an open schedule.
I don't really have an open schedule at that time. I tell you what I'm going to do. Clerk, is my schedule booked up for next week, and the week after, and the week after, and the week after, and the week after? It is?
Yes, it is.
I'll tell you what. Why don't you leave your phone number with the clerk, Mr. Adams? what I'm going to do is we're going to contact you when we're ready to have another hearing.
Your Honor, are you ordering him to get a psych exam? Will you set up the appointment and then call Mr. Adams and tell him the date and time and the person to which he has the appointment?
I think that's going to be it. Mr. Adams, do you have a problem leaving your phone number so the clerk can reach you when we want to contact you?
Well, Your Honor, I conditionally accept giving my phone number to the clerk of this court upon the condition that, or upon proof of claim that, this matter cannot be settled by merely allowing me to examine the original charging instrument such that we can settle this matter right now without spending any more public resources.
He is talking crazy. It's not going to harm this particular defendant to go through this exam just to make sure that he doesn't harm himself or anyone else. Instruct this particular gentleman that if he keeps repeating like this, he's in contempt of court. He's either going to obey the order or
It's all right. Let me tell you something. You've got a big problem.
I do.
You've brought some charges against this guy. You've got an open account here, so I'm going to tell you what. You'd better just consider that we just need to get him out of here because he knows what he's talking about, and maybe you don't know, but I'm going to tell you right now, just do it. Is that understood, Counselor?
Whatever you want, Your Honor.
Ready. Mr. Adams, what I'm going to go ahead and do is we're going to get a hold of you, and I'm going to strongly suggest that you go ahead and make sure that you get a mental evaluation, because when I have you back in this court next time, if you pull this again, I promise you, you're not going to be having a fine public defender like this, and these three gentlemen will be taking you away. So I want you to just get out of my courtroom right now, and you go do what I told you to do.
Your Honor, what was it that you wanted?
Just leave my courtroom now. I have other business. Goodbye, sir. Clerk, would you call the next deal?
Your Honor, is there any other
Goodbye,
business
Mr.
regarding
Adams.
Mr. Adams?
Goodbye, Mr. Adams. Have a nice day.
Well, Your Honor, would it be okay if I just want to ensure that there is no outstanding liabilities or obligations?
Mr. Adams, I have other matters to hear now.
Okay, let the record show that there are no outstanding obligations or liabilities for Mr. Adams. My business here is concluded. Thank you, gentlemen, for your time.
Now, you notice I didn't get his number. I gave it all up. I just want him to get out of my courtroom. Then he wants to close it up with the closing statement. Nice.
He's toying with contempt, even though we released him.
I wanted to make sure I was clear.
Oh, absolutely.
Have a seat, guys and gals. Thank you so much. You can hear how it's going to get. It gets very animating and very difficult, and it's tough to be as smooth as Jack or Brandon in court. It really is without a bunch of practice.
When you say goodbye, could he have just turned around and left? And he get out?
He could have turned around.
I could have, but I wanted to make sure. He did so much talking that I wasn't sure if the defendant still had an obligation or liability. I wanted to ensure there were no obligations or liabilities. And you got to be sure. Because the judge is throwing out so many things, he may have left in there some obligation or liability. If I'd have just heard, woohoo, I'm out of here, and chucked it for the door, not realizing that I just accepted whatever he put on the defendant, which may have been the evaluation, it may have been I have to return to the court, it may have been this matter's not closed. You know what I mean? So I wanted to make sure there's no obligations or liabilities. Because and by him not answering, he's acquiescing. And now I can put it on the record that there are no further obligations or liabilities for Mr. Adams.
He made a contract with me. See, he could have just let it all go and he might have been safe, but he doesn't know. I just kept running and rambling and threw some stuff and threw the kitchen sink in and a door and a carpet and a couch and everything I could find in the house. But I could see I'm not going to rattle this guy loose.
But at the end, remember, you've always got to watch that sneaky little take that toothpick out of your mouth. Just leave.
Mm-hmm.
And so if nothing else, Brandon would go, would it be okay if I left now without any further obligation or something to that matter?
Like what he did. Let the record show. There is no claim against the defendant or the defendant's property or collateral. Therefore, this concludes my business. Have a nice day. And I kept quiet. He made the final offer, and I let him walk out. I'm getting on to something else. I got too many people here. I didn't know this guy knew what he was talking about, and I don't want the people to see this. Or I might, as a judge, want them to see it. Because I want everybody here, just like We had a judge recently come in and assist. This is something so valuable for you to understand. These judges want you to succeed, contrary to how vociferous they get in their deals. Because everybody knows that has any smarts knows where democracy's in. They end in anarchy. That means I'm not going to have a job as a judge, and my family, friends, and neighbors are all going to suffer. What, you think I'm going to be happy with a dictatorship in America and people bolting and fighting? You got to be out of your mind. Nobody wins in an anarchy. Nobody but nobody. So I'm wanting them. I like it. And we've had at least 4 judges make very positive comments, which you can't always get at them, about our people that have done these kind of things. Including a friend of mine that went to Chicago, set off his stuff, and when he got done, the judge, after the 7th hearing, was pretty irritated. You've papered this court from wall to wall and blah, blah, I don't ever want to see you in here again. Then his clerk told him, hey, Judge, I want you to call him sometime. He called him around Christmas time. The judge took him to some big club in Chicago, downtown club in Chicago, for dinner. They had a nice conversation. The judge would not give any information up, but he told him lots of stuff he did right, including but not limited to asking questions was the right thing to do. He wouldn't give him anything new, but he told him everything he did right. He said he did a lot of things wrong, but he did enough right. And so look forward to it. We're at the end of our evening. We got a good day tomorrow.
One more thing I wanted to put in there. Don't be attached to how you think it should go and what you think you should say. If you go in there with a bunch of words in your head of what you think you should say, that's what's going to trip you up. The whole time they're up here going back and forth, I'm just being present to what's going on. I don't know what I'm going to say next. I don't know what I'm going to say till it's really coming out of my mouth usually. So just be present and have faith that the right words will come to you. Because then you won't get frustrated. You won't feel the need to talk over them. You can be courteous and just listen. And know that it's all contract. And when you hear the offer come up, decide at that moment, what am I going to do with this offer?
Do you understand me, Mr. Adams?